When is the interim order going to expire?
This month itself.
In this month. Very good.
Lordship, may I permit? Lordship,
Yes.
may I permit to mention for three matters, Lordship, there is a direction to file the affidavit, Lordship. Till date, no affidavit has been filed, Lordship.
Hearing matter.
Yes, Lordship, but affidavit not.
Ekটু পরে, কারণ there are a lot of motions. Let me finish some motions. Then you mention.
Lordship.
Your Lordship.
Mention it next week, please. Because only 2 days are here, today and tomorrow.
Yes, Lordship.
Thereafter, we'll be having a break of Saturday and Sunday. So next week you mention. Let me finish some matters so that I can add.
My lord, in this matter, your lordship, there was a direction for mediation, and the mediation is completed, and both the parties have come to the conclusion. Both the parties have come with the solution, your lordship, only for the disposal, your lordship.
Very good. And
My lord, may I be permitted to mention two matters? My lord, on the last occasion, the opposite party was directed to file the report, my lord, and for report, my lord, for inquiry.
May I be permitted to mention?
Under the Turkish Act, despite this order, they are taking the position with the help of police. So in this hearing, this is a motion, sorry. So I have resolved it.
hand over the slip. And give your slip.
Sir, slip is also sent.
My lord, may I be permitted to mention one matter?
Mentioning slip is pending by my senior, so I am. In 2 minutes, I am after.
Very well. Yes.
My
Motion.
lord, may I be permitted to mention?
Is it a motion matter? Motion.
My lord, may I be permitted to mention, my lord, one matter for application?
Hearing stage or motion?
Liberty to mention in the motion.
Very motion hole neven, hearing hole neven.
My lord, may I be permitted to mention, my lord, one application, my lord, before your lordship, my lord, because of extreme urgency of this is of recalling application, my lord. One of my learned friend, Miss Suparna Pali, is appearing before your lordship physically.
Recalling
My lord,
application of whose order?
Recalling application because here. Yes.
Recalling of whose order?
Recalling of this honorable court's order, my lord, where, my lord, and lookout notice has been issued against the private respondent whom I am representing, my lord, in a writ petition without even hearing the private respondent. There has, so my lord, I just cannot get inside the country right now because of this lookout notice. If I just hand up your lordship, my lord, the slip, and I'll just come and try to satisfy your lordship on the point, my lord. It's a recalling application.
Recalling, there is an order passed by the writ court, right? You want recalling of that?
Yes, my lord, passed by the honorable single bench of this court, by my lord Justice Amrita Sinha. So since this is my lord a circuit bench, my lord, the recalling application or review
Do I
application.
have
could be-
determination for that? Because recalling is
I get
usually
your
done by the
lordship,
same
since-
court. Recalling is
Because, my lord,
usually
this is
done by the same honorable judge if the same honorable judge is available.
My lord, subject to your lordship correction, since my lord, this is a circuit bench, and my lord, the
I'll
honorable
have
single
to check
bench,
up. You ask her to hand over the slip. It will be listed only if
I
I
can
am
satisfy
satisfied.
you. I can satisfy your lordship. I got the notification.
Not now,
issued by-
not now, not at the mentioning stage. Give the slip.
Absolutely.
Let us see. I'll also satisfy myself, and then it will come in the list. Otherwise, not.
Great, my lord. Great.
I've already given this slip.
ওটা রিকলিং টা আমাকে একবার দেখিয়ে দিন।
ছিল না যে অমিত সিনহা
একটা তো আমাদের সঙ্গে একটা হয়ে গেল, আরেকটা বাকি তো একটা আজ যদি করলাম না
Lordship, may I be permitted to mention one?
আগের দিন এসে বললো না
Hearing, please wait. Lot of
Lordship,
motions
this
are
matter
there.
is pending since January 2024.
हाँ
in
तो
the month
lot of
March.
motions are there. Please wait. Let me finish some motions. I have only begun today.
Lordship.
Let us
Another
make some
motion
headway.
matter, Lordship, in this matter, in the month of March, there is a direction upon the state to file report. But till date, the matter has not been.
Very well. We'll
It's a
see.
motion
Let us make some headway today. If mentioning is over, I can proceed. Try next week. Let us see how much we can proceed. Yes, please call on this.
কোনগুলো ইউজুয়াল বলো তো কোনটা কোনটা দেখো
Item number 1.
Your lordship, in item number 1, I am appearing on behalf of the CGST department. This is a service tax matter, your lordship. I have to take some more instruction from the department. That's why kindly fix it Monday or Tuesday, any day next week. I'm praying for adjournment for next week.
He wants it next week.
Any day.
On the prayer,
I'm ready with the matter.
Very well, I am recording his. Yes. The learned advocate appearing for, you are appearing for which respondent?
For all the,
All the respondents, CGST.
Learned advocate appearing for the respondents seeks seeks an adjournment in order to avail necessary instructions, full stop, paragraph. Accordingly, let the matter be adjourned and be listed again on Monday. Monday, you will be able to get your instructions.
Monday, Tuesday, Tuesday it will be better.
Tuesday, Tuesday date দিয়ে দেব।
Tuesday.
I'm grateful.
Grateful, man. Grateful.
Lordship, I am for the Union of India.
Appearing for the petitioner, my lord. May it please your lordship. My lord, this is a matter, my lord, where my refund was sanctioned by the authority at first. It's a GST matter. My refund was sanctioned by the authority. Thereafter, they had preferred a cross appeal. That preference of cross appeal is not the issue. The issue is, before preferring such cross appeal, they had initiated a review proceeding of the earlier order, in which they derived the subjective satisfaction that it should be gone up in appeal against. So, my lord, here this review order is a prejudicial order which was passed against me, and admittedly, they had never given me any notice. I was never invited to participate in that proceeding. Lordship will kindly take page 31 of the writ petition.
Page 31.
My lord, this is the refund sanction order, which says the ground of refund given, amount inadmissible, nil. So there's no show cause. Reply of show cause is also nil. Refund sanction order on verification of the refund application with relevant records. 1, 2, 3. These 3 refunds have been sanctioned. Accordingly, rupees so and so is hereby sanctioned. So, my lord, there was a complete cross-checking of all the documents in an adversarial system where I produced, they cross-checked, and thereafter the authority concerned came to his subjective satisfaction that the refund is to be given. Now on the next page, page 32. This is the petition or memorandum of appeal. My lord will see at page 37, review order. Yes, at page 35, my lord kindly comes.
Yes.
Within this petition, they have annexed page 35. Lordship says order in review number 3/review/CGST unreadable/SLG, that's Jalpaiguri, 2023-2024, dated 18/8/2023. Statement of facts, my lord kindly sees. The claimant assessee submitted an application for refund, a claim of refund in form GST so and so for refund of so and so of excess balance in electronic cash ledger. The refund sanctioning authority vide impugned order sanctioned the entire refund of rupees so and so. The impugned order does not appear legal or proper inter alia to the extent the sanction so and so on the following grounds. On examination of the document, so here,
Yes, proceed.
my lord, lordship is desirous of looking up section 107. 107, my lord, subsection 2 will be relevant.
Yes, 107. subsection 2.
May I place the provision before your lordship?
Lordship, may I,
একটু বলে নি, একটু বলে নি।
হ্যাঁ, আপনি বলে
Thank you.
because
May I place the provision, my lord?
Yes, yes,
Yes.
I'm at it.
Ma'am.
I'm on the provision.
My lord, my lord. दिखा दिया.
And where is the provision for review?
There is no provision for review. That is what I'm on. 107 subsection 2.
In any case, even if they have said that it is an order in review,
right.
and they are passing an order in exercise of section 107 subsection 2, thereby deciding to prefer an appeal, how can you be aggrieved by that? Before the appellate authority, you will get a hearing.
No, because no, I participated in the appellate authority's hearing, but
Then
that was also.
This order, prima facie, subject to hearing you further.
Well,
This order does not appear to me to be prejudicial to you, because an order would be prejudicial if it gives rise to civil or evil consequences. Now, a person has a right to prefer appeal in terms of a particular provision of the statute. That person invokes such provision and prefers appeal or decides to prefer appeal. This decision to prefer appeal per se would not be an act causing adverse consequences or adverse effect on the adversary. So this, in my opinion, prima facie though, subject to hearing you further again, I don't find there is anything prejudicial to you.
my lord,
which
only
can be
one
challenged
thing.
here in writ.
My lord, only one thing, subject to correction from my lord. Here, what has happened, had there been no review proceeding at all, they decide upon their own subjective satisfaction that no, this order needs to be challenged. And then they go before the appellate authority on their own cogent grounds. I would have been in a position to oppose that. But
No,
in this
suppose,
appeal,
Mr. Counsel, suppose even without this review proceeding, they come to a decision. Are they not entitled to?
they are completely entitled.
Then
But the question is, in the
merely because, see, you are also aware, it is well settled now that if I have power,
my lord,
which can be rooted to a source in the statute, and I exercise that power, merely because I have exercised that power in a different name, that exercise per se will not be illegal. That is settled. For example, if I have two
True.
sources of power, or I have three sources of power, I have exercised one of them apparently,
my lord,
but the power actually should have been exercised under the second or the third limb of the provision in the statute. If I can satisfy that yes, my power is there and it can be rooted or connected to this limb of the statute, then in that case, my exercise will not be annulled by any court of law.
True.
So going by that logic, why should I interfere at this stage? In the
Because-
appellate court, you will have,
no,
or if you have
the
appealed,
appeal order has been passed. I have actually challenged the appellate order.
then
But I'm just showing your lordship here
this,
in the
then what is wrong in the appellate order?
No, my
Because
lord,
this-
before we go to the appellate order, lordship kindly takes page 33. That is the statement of facts and the grounds of appeal.
Yes.
Kindly lordship sees grounds of appeal. Paragraph 8.
Yes.
On examination of the documents, it was observed that the claimant SSC had declared the outward supplies for the relevant period so and so in their GSTR 1 as so and so and GSTR 3B as so and so. However, the outward supply as per section 51 of the CGST Act were found to be much higher. Now the question is, where from did they get these findings? I
The
can
appellate authority will
I
have to
can
decide.
controvert this only when I get the material, and that genesis lies in this review. They had once again gone through the documents and they had reassessed behind my back. There is where I am aggrieved. And unless they give me that material, my lord, I will not be. Now, lordship kindly takes the order of the appeal.
Yes.
The same problem lies in the order of the appeal as well.
Yes. There is no remedy against the appellate order.
No, my lord, the GST tribunal is not yet made. So, as a natural consequence, 226 is the only course to follow.
Yes.
My lord. Lordship kindly takes page 42. That is the grounds of appeal. The same thing that has been stated there, here also it has been recapitulated. And then at page 43, discussions and findings. paragraph 8.3, from paragraph 8.3 will be, rather 8.2, Lordship kindly sees, I find that the instant review order issued by the commissioner and consequent filing of appeal by the authorized officer had been made within the condonable. So this is pursuant to that review again and thereafter. I find that the respondent filed an appeal for refund so and so, accumulating so and so for the period so and so, on the ground of excess balance in electronic cash ledger. The taxpayer declared the value of outward supplies in their GSTR 1 as so and so, GSTR 3 as so and so. After verification of the refund application along with relevant records of the taxpayer, lower adjudicating authority, VDA, order number so and so, sanctioned the entire amount. On reanalysis by the reviewing authority, Lordship kindly sees, on reanalysis by the reviewing authority, it was found that the respondent declared, now this reanalysis happened completely behind my back. The respondent found, I declared that the outward supplies for the period of September to so and so is as rupees so and 3B as so and so. However, the outward supplies as per section 51 is so and so.
Let us have a look at section 107, subsection 2.
2.
Lordship.
Right.
What does it say? It says that the commissioner may on his own motion or upon request from the commissioner of the state or the commissioner of union territory such and such, call for and examine the records. So what will examination be if it is not revisiting the documents? What else is examination? Examination is that only. How else do I examine? If I don't revisit the documents, if I don't go through the material, how else do I re-examine? Examination is all that only.
That's true.
So I do not find
That's
it
true.
documented.
Now the question is here, once they say that this is the examination done, I am not on the review proceeding at all right now. Once they say I have found out these things in review, they must declare it in the appeal. Otherwise, I do not know what I am facing.
What they have found has been stated.
Stated means under section 51, I find it this.
Yes.
How can I refute such a finding?
No, it is your material only from where they have found.
No,
Yes.
no,
Yes,
Lordship
yes.
kindly sees page
Tax
section.
ledger is whose material? It is your material.
It is my material now. Now,
It
Lordship.
is not that something of their own or they have discovered something from a third party.
Yes, it's a third party document. Section
How?
51. Section 51 refers to TDS. Section 51 refers to the TDS. Lordship,
TDS is
kindly text
available
page
to you
50.
also. TDS is in public domain.
Yes,
TDS is not
definitely.
available to
No,
you.
this TDS is regarding the GSTDS. Kindly come to
So
section.
that should also be available to the party whose deduction it is.
Correct.
But
correct.
my lord, how
It
they are
cannot be
coming to it,
unilateral.
how they are coming to it must be
You also will have to go through the same document then. Through which they
correct.
have
Where
to
is
go.
that? Where is that?
The same thing which is available to you has been available to them also.
My lord, where from did the findings come? I must know that. Unless I know the findings,
So then why did you not make this submission before the appellate?
I
authority?
did.
Where is that?
My lord, I did, but it was not
Where?
recorded.
No, then you have to approach the appellate authority itself. You know the law much better than me. Then
My lord, I am not
if-
in it. I will
if
happily
you
go
say-
before the appellate
if
authority.
you say you go, but I will not set aside this order for
But
that
then
because
how
you
can I
ought
go?
to have gone. You ought to have gone. Law is well settled that
How
if you
can I
say,
go before the appellate
Mr.
authority?
Counsel-
The appeal is done.
Mr. Counsel, law is well settled that if you say that something has been submitted and has not been recorded, the proper course is to approach the same authority by filing an appropriate application. If that is not considered, you have remedy before the other higher
My lord,
forum.
the question is,
Lordship.
once I have given it and there is no provision under the law under which I can file.
Permission is required if you feel that something has been submitted by you and has not.
It is electronic. It is electronic. I cannot file it.
You should have made a representation then. Why
Lord,
electronic?
before whom?
Electronic is
Lordship.
filing before the authority who
Lordship.
considers it.
You know, the appellate authority
Lordship.
here is not my appellate authority.
आवाज
It
किधर
is
से?
somebody regarding the
ठीक है,
faceless
बोल-
transaction they have been.
Lordship.
Very well, you were
Lordship.
granted a time of hearing. You
Lordship,
were
may
not
I-
granted
Lordship.
to make representation.
No,
It was without.
It was on-
natural justice.
it was past expertise.
No, it's a
No, for the
No,
first
kindly-
day I appeared,
Yes.
the first day I appeared,
then-
and on the very next day it was past expertise.
No, it's a wrong
Lord-
submission.
No, Lordship will kindly see once.
Show me.
Here,
Show me.
let me read the order for you, Lordship.
Yes, please.
Yes.
Don't read the entirety of it.
It's
Read
only a
the
2-page.
Page,
matlab,
page
it's only
44, relevant paragraph.
before, no, let me complete page
Because this
43.
is the conclusion
Now,
part.
reference may kindly be drawn towards the subsection 6 of 49 of CGST, which clearly states that the balance in electronic cash ledger or electronic credit ledger after payment of tax, interest, penalty, fee or any other amount payable, whatever they're quoting that
Kindly see page 43.
Yeah,
43 I am on.
43 top.
Who-
The-
No, my lord, I am
the
not on it. I
practice
have said I have appeared.
Not only appeared,
Hmm.
you physically appeared for personal hearing, reiterated that they have filed their return in proper.
Yes.
Yes.
They further stated that they will submit such and such, and reconciliation statement along with other relevant document in support of their claim.
Within 10 days.
Within
You
10.
could have submitted what you are submitting now, that you give me opportunity. You did not. This
Where-
does not show, Mr. Counsel, that you sought for an opportunity to get those documents on the basis whereof this was done. Now,
My
this
lord,
case you are making
My
before
lord,
the writ court today.
no, my lord will kindly
Lordship.
have a go at my submission, my lord. Lordship will kindly see. Here, it is on record that I had claimed to produce all the other documents within 10 days. Now, unless what is the lordship knows much better than me, what is the procedure of an appeal?
I
The
don't-
next day is
I don't know anything.
the next day is communicated to me. My lord, the next day is communicated to me. There was no further communication regarding the next date. Straight away this order was passed. Lordship kindly sees on 16/11/2023 I had appeared, and this order is being passed on somewhere in December.
No, 5/12, 5/12.
5/12.
Yes, December 12,
So you sought
2023.
for
So
10 days, Mr. Counsel, you sought for 10 days to submit document.
Correct.
Within those 10 days only, you could have submitted your representation also containing all the submissions that you are
my lord,
making. before
unless
me
the
now.
date of hearing is given, how will I submit?
You
The
submit.
file
that
will not be
represent-
there. The file will not be there with the authority.
Make
No.
submissions.
My lord, how can I?
Why not? You say that within 10 days you will submit
Lordship,
relevant
may I-
documents.
Lordship will not take me
Within-
amiss.
No,
May I
I-
give an illustration? May I give an illustration?
Lordship,
Today the matter is taken up. Today the matter is taken up by this honorable court. I am supposed to file a written submission. The date has to be fixed someday. If the date is not fixed, tomorrow I come back with a written submission, Milord will not find the file here.
Now let me give another illustration. Today a hearing is taken. You undertake to file a written submission within 10 days.
Yes.
You do not file it within 10 days. After 10 days, I'm entitled to pass an order. I make a matter, I reserve a matter for judgment. You seek time saying that within a week, I'll file my written statement. I'll file my written notes of arguments. Within those 10 days, you don't file your written notes of arguments. What am I to do? Am I to search you and say, no, you have not filed, therefore I have to wait?
No.
Then I'll deliver judgment.
No.
It was on you to file all the relevant documents. All the relevant documents should have included this
My
submission
lord,
also, sir.
when these things
Lordship.
happen, then a date is fixed. A date is fixed for
You
submission.
yourself have fixed the date 10 days.
yes.
I had prayed for 10 days and
That has been granted.
how do I know?
Because they didn't say that I'm not granting you.
But how will they say I am not granting you? They are supposed to give me a notice.
This is
How do I know it is granted?
Notice for hearing every time.
Yes, they give it. Every time they give it.
Lordship, may I?
My lord, kindly take
Lordship.
my lord, kindly take subsection 10. There is a provision
Lord-
for giving 3 adjournments at least.
You didn't
No,
seek
if
for
it-
adjournment.
Yes,
No,
definitely.
I wanted,
Then
my
why
lord,
are you
I
showing that
wanted
provision?
a
That
time,
provision
my lord, I
doesn't apply.
wanted a time to
No,
submit the
Nothing.
documents.
nothing.
You have not come up complaining that despite granting me time, they have not, despite asking for 10 days, they have not given 10
I
days.
have made this complaint.
But that doesn't.
This is
appear-
there in the petition.
Sir, from the record, it doesn't appear. The order has been passed on 5th of December.
Yes.
The hearing was on 17th November.
My lord,
Correct.
from
How
the-
on earth do I believe that it is before 10 days?
No, lordship, kindly, probably I'm not being able to reach my lord. My lord,
No,
kindly
you have
see.
reached your, you
Well,
have reached
Lordship,
more
may I-
than
My lord,
required.
kindly,
This
kindly
is not
see.
maintainable,
Kindly
Lordship.
see. My lord, kindly see what has happened here. Even the appellate authority records that within 10 days, I'm supposed to grant this. I'm supposed to file this.
Yes.
Now, my lord, unless he gives me a date or a time, how do I know, my lord? Because it is
Page 44, Lordship. Kindly see page 44, para 8.5. It's a clearly stated, it is also pertinent to mention that during the personal hearing held on such and such, the respondent stated they have filed the return proper manner and also promised to submit the relevant documents substantially within 10 days. However, no such documents has been received from the respondent till date. And
Yes,
after
how
that,
can I do it?
No,
Because
and-
my lord,
No,
I have
Lordship-
given a clear averment in the petition.
Lordship, I have got the other submission.
I have
Because this rate is not maintainable, kindly
Why?
see the para because he is not come with the clean ends.
Eh?
Kindly see, yes, I am giving you the document. Kindly see page 4.
Page 4.
Yes. Para 2, Roman 2.
Page 4, para 2. Para Roma, II.
Yes, yes.
Yes.
The said refund application was filed under the category excess balance in electronic cash ledger as the funds were deposited inadvertently. So kindly mark, they have deposited the funds inadvertently and they remain unutilized. Thereafter, upon the submission of the refund application, the acknowledgement automatically generated by the GST. Lordship, I am filing because they have not deposited any amount. So this is the their cash ledger, electronic cash ledger, wherein there is no whisper of deposited any amount. 6,000, 6,50,000, though they are claiming.
My lord, if I have not
No,
deposited, how
and-
does it come?
No, no.
It has to be
No,
deposited
no, no.
sometime or the other.
No, 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 my lord. I will just, I will
If he has
just.
not deposited, how will this come?
Yes, it will come.
Why the
I will
checks
come.
there?
I will just explain. Because you see, if some TDS is being deducted, whatever the work he has done, so when the deductee deducted the TDS, it will suited to the electronic cash ledger. So that is the amount because.
That is the same
No,
thing.
no same thing because he is saying I have inadvertently deposited. He has not deposited. It is the government or his contractor, he has deducted the tax. Because categorically he has stated that 6,50,000, 6,50,000 he has deposited.
Lord, you kindly see page 30 of the writ petition.
No, no, no.
Kindly see page
please.
30 of the writ petition.
Just a minute, let him complete.
Yes, I will.
I have deposited and that is here. I have
Very well, I'll
No,
come,
anyway.
I'll come
No,
back to you. I'll come
no.
back. to you.
Let him give the challan then. I will give him
Baba.
in affidavit.
Lord, even if it comes back from my TDS, that is also my money.
No, then-
I have used it. I have
Then
not used it.
then lordship, he cannot say, I have deposited. I have
This
deposited.
has got no bearing with the case. My lord.
No, definitely you are giving the wrong submission.
What wrong submission, my lord?
No,
This is my
if
money.
you
It
see-
has come.
You see,
If you want to say it's not my money.
I'm fixing it tomorrow again. I'm prima facie not satisfied. I'll think over it. You also think over it. Let us meet
My
tomorrow.
lord,
no, lordship.
may I just indicate one
Lordship,
small
only-
thing. As far as all the other questions are concerned, my lord, I am not on it. I am only on the point that you are filing an appeal against me in a cyclo-styled manner. I do not know what is against me. I ask you for 10 days time, give me 10 days time and I will appear and produce everything. The revenue is not getting hurt. The revenue is not getting hurt on that.
We'll-
Lordship, this is the order, appeal
Lord-
order. Lordship, kindly.
Hard learned advocates appearing for
And this is the order of 2023. He is coming 2025. So after 2 years, he is filing the writ.
that's
You
an
see,
important point.
because he is very much cautious
is more
about the 10 days. Now he is coming before the
I will-
earlier,
I will not expend myself on this today.
because earlier.
Since I have another day for a choice, my lord, I will reserve my cards
In the
for that day.
earlier bench, they, learned judges is like to dismiss the case on this very issue.
No, no.
So
On the
that's why
first
I'm
day,
taking
on the
this.
first day, I was going to get the order. On the second day, the table turned, and today
No,
it seems the
because-
table has since turned, and it has not yet
because-
upturned. Let me see. Let me
We
see in the
have to
next
see-
occasion if I
we
can.
have
Take
to
a dip
see-
on Tuesday on this ground then.
My lord,
Don't take a dip on Tuesday on this
never,
ground.
never. If I'm submitting before my lord, that I'll
But
be
my
there. on
submission,
Tuesday,
my
I'll be there.
submission, my
Even
submission.
if not physically, but online, I'll be there.
No, be there.
My lord,
It's all part of the game.
my lord.
I've been on that side, I've seen it.
But I will take.
That lordship I have known from my 2007 days Justice Bose's court. That I have seen, my lord. Grateful,
Thank you.
grateful.
Lordship, for item number G, I'm praying for not today. They are
Not
okay,
today,
record is
not today.
okay on record is
Not
not well, Lordship.
Not today.
They are praying for afternoon.
Very well, only not today. Tomorrow, if madam, make sure tomorrow you,
Lordship.
tomorrow they'll do it. Don't worry.
But see, in item number 2, some order may be passed, otherwise you will say that.
I said, heard learned advocate appearing for the
Oh,
parties. Order pass holo to.
Oh.
The number of order
Yes.
pass holo.
I,
Tuesday, yes, I fixed.
sorry.
Order was passed. It's only heard learned advocates appearing for the
definitely.
parties, let the matter appear.
Yes, yes. Otherwise you will say that tomorrow not, there is no date. As in
No, no, it's
disputing.
It was passed in open court.
Yes,
Well, I'm on behalf of the petitioner, my lord.
Yes.
My lord, I have challenged over here the
before the
lord.
learned council starts, I will have the small submission because this is the appealable order. So
That's why I'm
it's not maintainable.
my lord.
So this is the first.
First. My lord, I have filed this writ challenging the intimation notice, the show cause notice given by the respondents' authorities to the present petitioner, as because, my lord, it is not beyond their power. They cannot give a 74 notice to the petitioner in his individual capacity, my lord. And my lord, there is also a case of violation of natural justice. Now, my lord, I come to the fact of the case, my lord.
Why do you say that it is beyond their authority?
My lord, if your lordship comes to the circular which I have annexed, my lord.
Page?
My lord. Page 709. Annexure P8.
709.
709. The allegation against the petitioner is that he has been issuing fake invoice and circulating ITC.
709.
709.
Yes.
So, this is a clarification given on such issues, madam. It says subject clarification on various issues relating to applicability of demand and penalty provision under the Central Good and Service Tax Act in respect of transaction involving fake invoice. Now, it says, my lord, that issues and clarifications, my lord. It says, in case where a registered person A had issued tax invoice to another registered person B without any underlying supply of goods or service or both, where such transaction will be covered as supply under Section 7 of the CGST Act, and whether any demand and recovery can be made from A in respect of the said transaction under the provision of Section 73 or 74 of the CGST Act, also whether any penal action can be taken against the registered person A in such cases. The answer is, my lord, clarification. Since there is only been an issuance of tax invoice by the registered person, it's very important, by the registered person A to registered person B. Now, my lord, my petition is not a registered person, my lord, without the underlying supply of goods or service or both. Therefore, such an activity does not satisfy the criteria of supply as defined under Section 7 of the CGST, as there is no supply by A to B in respect of such tax invoice in terms of the provision of Section 7 of the CGST Act. No tax liability arises against A for the said transaction, and accordingly, no demand and recovery is required to be made against A under the provision of Section 73 or 74 of the CGST Act in respect of the same. Besides, no penal action under the provision of Section 73 or 74 is required to be taken against A in respect of the said transaction. The registered person A shall, however, be liable for the penal actions under Section 122(1)(2) of the CGST Act for issuing tax invoice without actual supply of goods or service or both. Now, my lord, number 2, my lord.
In my case, my lord, I'm not a registered person. I'm again saying, my lord, my farm has also been given the notice, my lord. Now, I have been given this notice in the individual capacity. Number two, my lord. A registered, again it says, a registered person A had issued tax invoice to another registered person B without any underlying supply of goods or service or both. B avails input tax credit on the basis of the said tax invoice. B further issues invoice along with underlying supply of goods or service or both to his buyers and utilizes ITC avails on the basis of the above mentioned invoice issued by A for payment of his tax liability in respect of his said outward supplies. Whether B will be liable for the demand and recovery of the said ITC along with the penal action under the provision of section 73, 74 or any other provision of the GST Act, the answer is since the registered person, again registered person B, has availed and utilized fraudulent ITC on the basis of the said tax invoice without receiving the goods or service or both in contravention of the provision of section 62B of the CGST, he shall be liable for the demand and recovery of the said ITC along with the penal action under the provision of section 74 of the CGST, along with the applicable interest under the provision of section 50 of the said Act. Further, as per provision of section 75(13), it's important, if penal action for fraudulent availability or utilization of the ITC is taken against B under section 74, no penalty for the same act, that is for the said fraudulent availment or utilization of the ITC, can be imposed on B under any provision of the CGST, including under section 122. That is, if anyone has been given a 74 notice, 122 notice cannot be given against him, because the 75(13) clearly says that if you're availing false ITC, then you can be given a 74 notice. But in that case, if you're being penalized under 74, you cannot be given a 122 notice. Now here, number 3 point now, madam. A registered person A had issued tax invoice to another registered person B. Everything is covered with registered person, madam. A registered person B without any underlying supply of goods or service or both, B avails ITC on the basis of the said tax invoice and further passes on the said tax credit to another registered person C by issuing invoice without underlying supply of goods or service or both. Whether B will be liable for the demand and recovery and penal action under the provision of section 73, 74 or any other provision of the CGST. The clarification is, in this case, the ITC availed by B in his electronic credit ledger on the basis of the tax invoice issued by A without actual receipt of goods or service or both has been utilized by B for passing on of input tax credit by issuing tax invoice to C without any underlying supply of goods or service or both. As there was no supply of goods, service or both by B to C in respect of the said transaction, no tax is required to be paid by B in respect of the same. The ITC availed by B in his electronic credit ledger on the basis of the tax invoice issued by A without actual receipts of the goods or service or both is ineligible in terms of section 62B. In this case, there was no supply of goods or service both by B to C in respect of the said transaction, and also no tax was required to be paid in respect of the said transaction. Therefore, in this specific case, no demand or recovery of either ITC wrongly fraudulently availed by B in such case or tax liability in respect of the said outward transaction by B to C is required to be made from B under the provision of 73 or 74 of CGST Act. However, in such case, B shall be liable for the penal action under section 122(1)(2) and section 122(1)(7) of the CGST for issuing invoice without actual supply of goods, utilization of input taxes without actual receipt of the goods. Now, if supposedly a person A sells goods to B, B thereafter sells to C, the person who is buying that good will also be penalized under 122(1)(2) or 122(1)(7) of the CGST Act. Now, what will happen, my lord, if a person, whether an individual person in his individual capacity can be penalized under this provision of 122 or 174? Now, it has been stated in point number 2, my lord. Says that, my lord, the fundamental principles.
Take it easy.
The fundamental principles.
Yes, you want to say something?
No.
That have been delineated in the above scenarios may be adopted to decide the nature of demand and penal action to be taken against a person for such unscrupulous activity. Actual action to be taken against a person will depend upon the specific facts and circumstances of the case which may involve complex mixture of above scenarios and even may not be covered by any of the above scenarios. Any person, this is important, any person who has retained the benefit of transactions specified under subsection 1A of section 122 CGST Act and at whose instance such transactions are conducted shall be liable for the penal action under the provision of the said subsection. The allegation against the present petitioner is that he is a kingpin. He is circulating ITC by issuing fake invoice, and if any, as because they are making him personal liable, my lord, he can be made liable under 122 1A of the CGST, but not under 74 or 122 of the GST Act, my lord. With regard to which the penal notices have been given to him, and also it says. It may be noted in such cases of wrongful fraudulent availment of ITC or in case of issuance of invoices without supply leading to wrong availment of ITC refunds of tax provision of 132 of the CGST may be invocable. 132 has been invoked against him, my lord, against the present petitioner. Now I would like to show my lord the intimation notice first, my lord, which is in page number 40. Four zero. It is in the first volume. Volume 1. It is in the first one.
Yes.
Now, my lord. First, my lord will see, my lord, a consolidated notice have been given. Not only to Rajesh Kumar Sarda. I have filed this present writ only against Rajesh Kumar Sarda, not against any other firms, my lord. So Rajesh Kumar Sarda, PAN number. And other firms, my lord, Rajesh Kumar Sarda happens to be the proprietor of Krishna Trader, which is number 7, my lord. Proprietor Sri Rajesh Kumar Sarda, my lord. And Rajesh Kumar's wife happens to be the proprietor of Ma Durga Traders. They have also been given the notice. And his daughter happens to be the proprietor of GN Traders. And Rajesh Kumar Sarda is also has opened up a Rajesh Kumar Sarda and Sons firm, my lord. My lord, the thing is that
So it's 1, 4, 5, and 6.
Yes, my lord. So the allegation against him is that he was issuing fake invoice against this firm's name, and without supply of goods, my lord, he was circulating ITC. That is the allegation against him. So even if that is the allegation against him, my lord, against Rajesh Kumar Sarda, 122 1A will be applicable. A notice can be given against him under 122 1A, not under 74 or under any other provision of 122. My lord, that is my first submission, my lord. And if your lordship sees this intimation notice, my lord, page 41, my lord. Page 41. It speaks about the period April 18, March 19, April 19, 20, 2021, 21, 22, April 22, November 2022. Now, if your lordship comes to the show cause notice, my lord, which is in page number 50, my lord. Page 50. It is in the first volume itself, my lord.
Yes.
Now they have given a show cause notice from the year 2017, July 2017, my lord. Page 85 of the show cause notice, which was never stated in the intimation notice. Now, interestingly enough, my lord, the summary show cause notice shows about the year 2018-19, 19-20, 2021, 21-22, which is page number 267. 267 of the volume 1, my lord. It's the last page of the volume, my lord. 1. Volume 1, 267. 267. 1890, 1920.
Hmm.
My lord. It never speaks about 1718, my lord. And interestingly enough, my lord, the adjudication order has been given for the year 1718, my lord. My lord, page 692, volume 2. Volume 2, that. Sir, this order is huge, so 692. Para 5.62. .61 speaks accordingly ITC availed and passed on the basis of invoices issued without any underlying supply of goods by their supplier by the said 8 firms of during the period 2017 to March 2022 are ineligible and contravention of the law. And this has been done, my lord, because 1718 was barred by period of limitation. They have given a compounding notice, a consolidated notice, my lord, and I am citing a judgment, my lord.
No, but the show cause notice does not, it does refer to the period 2017, but the incidents that are referred to are 2019 onwards.
Information notice, 1718 doesn't mention. In the summary show cause notice, they mentioned 1819, my lord. 1718, they did not mention, but inside they have put 1718 because it was barred by limitation. That's why they purposely did not mention it, give the notice under 1718, my lord. That's why the intimation notice was also not served under 1718, my lord. And into that score, my lord, I believe.
There, okay. नहीं कैसे you you are relying on such a voluminous papers.
She has done her homework very nicely.
Pardon?
She has done her homework very nicely.
Yes, yes.
These junior members are doing well, very well. We are impressed.
Yes, yes. She is
Hard work.
our one of the very.
There is yet another aspect of the matter. If
Page.
Page para 8, my lord.
Para 8.
Para 8. There is yet another aspect of the matter. If a consolidated notice of various financial assessment years is issued, the total amount of tax, penalty, etc. determined as payable by the assessee may increase exponentially depending upon the number of financial assessment years included in the consolidated notice. The determination of tax, penalty, etc. would be in respect of all financial assessment years put together. That would go against the provision of subsection 9 and 10 of section 74, which specifically refers to the financial year to which the tax not paid or short paid or input tax credit wrongly availed or utilized relates, while stipulating the last date for passing the adjudication order. Why it is said, my lord? Because 74/910 says that the adjudication order is required to be passed within 5 years. Right? That is what I say, my lord. 1718 is barred by period of limitation. A consolidated notice would also result in a consolidated adjudication order covering several financial assessment years, and in the event of it being adverse to the assessee, the fee pre-deposit required, this is very important, required to be paid by an assessee for preferring a statutory appeal would be higher. In my case, my lord, 40 crores. I have to pay 4 crores in order to file an appeal, my lord. This could not have been the scheme of the statutory provisions which are expected to adhere to the principle of fairness in taxation. In this context, it is useful to remind ourselves of the following observation of Justice H.R. Khanna in CIT versus Simon Carbs Limited as regard the nature of the quasi-judicial function exercised by the assessing officer. The taxing authority exercises quasi-judicial power, and doing so, they must act in a fair and not a partisan manner. Although it is the part of their duty to ensure that no tax which is legitimately due from an assessee should remain uncovered, they must also at the same time not act in a manner as might indicate that scales are weighed against the tax.
Yes.
Second judgment, my lord. But very much technology.
Not supplying any judgment, but I am not.
You take your time.
Yeah.
Let her finish.
Huh?
Yes, ma'am. Yes.
It says, my lord, the petitioner relies on the judgment of Honorable Matters High Court in the case of Titan Company Limited versus Joint Commissioner of GST and Sales Tax. The Madras High Court, while addressing similar issues, relied on the Honorable Supreme Court's decision in state of Jammu and Kashmir versus Calcutta Limited. The Honorable Apex Court held that where an assessment encompasses different assessment years, each assessment order can be distinctly separated and must be treated independently. This court has reviewed the judgment of Madras High Court and the scope of inquiry under 73 of the SC Act based on the established legal principle and the precedent set by the Honorable Apex Court. This court finds that the respondent in issuing a consolidated focus notice for multiple assessment years spanning from 2018 to 2020-2021. Section 7310 of the CBST mandates, which is a 73, there is a limitation period of 3 years. In 74, limitation period is 5 years. Mandates a specific time limit from the due date of publishing the annual returns for the financial year to which the tax due relates. The law stipulates that particular action must be completed within the limited year, and such action should be executed in accordance with the law's provision. The principles enunciated in the judgment cited by the Honorable Supreme Court are directly applicable to the case. So it was set as notice.
So principally, you are attacking the show cause notices on 2 grounds.
Not only show cause, intimate notice.
Very well, on 2 grounds. One is that since the petitioner is not a registered entity, therefore they could not have been struck with a notice under section 74 and 122. And second is that a consolidated notice for several years together, including those years for which a proceeding would be time barred as at present, could not have been issued. These are the 2 principal grounds on which you are attacking the notice. Yes.
Lordship, this is a case of fake invoices. The petitioner he is holding the 8 firms. So he is also booked under 132. So present before the SCGM court. After that, bail is granted. So now proceeding is going on. So, and voluntarily they have paid some amount because she also.
But what is your answer to the 2 points that she has taken?
One, he is showing the scroll side because that is the limited space.
No, she says that this notice could not have been issued unless the person is registered. It
No,
is only if the
actually
person
kindly see the section 2 definition clause.
Section 2.
Yes. 84.
284.
2 section 84.
Yes.
So person includes individual.
No, it's not about individual or a corporate entity or a firm. It's about whether registered or unregistered.
I will just say,
Because she is relying on a notification issued by the department.
yeah, that is only for the registered person.
So that is what she's saying. She's saying that it is applicable only to registered persons. If a person is not registered, then the applications will not apply. The provisions will not apply, not applications.
No, that also 122 2A, there is the, in the last para,
I'm saying that to give the intimation notice as per the circular, nothing more I have claimed. To set aside this and give a fresh intimation notice as per their own circular, nothing more than that.
Section 122.
because 2, the page 711,
No, show me this section.
no,
Let us
he-
have a look at this section.
the circular he is relying on,
Yes.
that is at page relevant 711. Because on that basis,
Yes. It is as page 709.
709, 709 speaks about the registered person who have continuing the business
So it
without supply.
applies, according to you, it applies across to everybody, whether registered or unregistered.
No, unregistered also e prima facie, because the findings is there in the adjudication
What
only.
does this section say? Let us read this section, then we shall go to circulars, because circulars won't override this section.
My lord,
Section is the parent
absolutely.
statute. Let us see what this section
Absolutely.
is.
The simple principle is that if there is the threshold limit in every act, in the GST Act, 40 lakhs is the threshold limit. If somebody individuals doesn't take the registration number and he crosses the threshold, even he is not registered,
Registered person,
then
my lord.
also, no, he is,
I am a registered person, my lord. Krishna Traders has been given a notice, my lord. In the intimation notice, Krishna Traders has been made a party, my lord. I have been given a notice under 74, being a registered person. And they are also giving me a notice in my individual capacity, my lord. This is
What is that? That is a firm.
That is-
Registered
my lord, proprietary firm.
Proprietorship.
Yes, my
So
lord.
maybe because of that, because a firm
My lord.
is only a compendium name. It's only a compendium name. It's not a corporate entity.
My lord, but
A firm will not have separate existence. A firm owes its existence to
Absolutely.
the person who is
Absolutely.
owning it, right?
Absolutely,
So
absolutely.
therefore, they might have given notice to you. That can be.
My farm has also been made a party, my lord.
Very well.
My
Because the firm without you has no meaning. Without the living person at the helm of the affairs of the firm,
Yes, my
firm has no meaning.
My lord.
So if I only issue a notice to the firm,
Yes, my lord.
without issuing notice to the person who is controlling
but-
the firm, it will make no purpose.
No, my lord. The provision of law is very clear with regard to 122 1A. The allegation. One 122 1A.
122
Any
1A
person who retains the benefit.
retains the benefit.
Yes. So why do you show registered and unregistered? Because if you are a firm, you say you are registered as a firm, maybe not as a person, but you are the owner of the firm which is registered. Then in that case, you come under that clause.
Isn't a case of double jeopardy? My lord,
Could be.
my lord, they are
Not
giving.
It will be a case of double jeopardy if for the same offense you have been booked twice.
Yes.
This is a notice which is served to you in two capacities. It is not that you will be asked to pay two penalties.
I am being asked to pay two
Two
penalties.
penalties, no, that they can't do.
That they have done, my lord. That they have done.
How can they be asked to pay two penalties? If it is only by the person concerned, then he will commit offense only once. If he has been operating through his firm, yes. If you're in your personal capacity, also you have acted and you have committed the same offense.
That is why I'm saying I have to be given a notice under 122 1A in my personal capacity with regard to 8 form.
She is right there, sir. She is right there. If by way of her client being a proprietor of a firm, notice has been given to the person for the offenses of the firm or for the wrongdoings or for the illegalities committed by the firm, then in that case, yes, that notice is valid and properly served. But if for the person, the notice is given, again in respect of the same act for which the firm is made liable, then that is difficult. That becomes problematic.
Lordship, because the facts of the case, because it's about the entire fact, either it has to be decided in affidavit, because there is so many other facts also there. So if we are taking the one fact, other fact we are losing, because this is the adjudication of 900 pages. So if we do like to conclude it within this way, it's most probably for me, I will just suggest then we should the
How soon can you
affidavit,
file your affidavit?
because this is the 800 pages. So time
800 pages?
accordingly,
800 pages, you will not be required to traverse the entirety of it. File it within a week. And within the next week, he'll file reply. After 2 weeks, we'll hear it again.
yes,
Very good.
give 2 weeks. Because this is the matter of 132, Lordship, because it's the fraud case. So how this defense can be this?
Massive action will they take immediately after issuance of?
Now, take a recovery proceeding against whom?
I'll keep that option open. You make that prayer again if they don't finish that affidavit within the time frame. Interim order, I'm not.
So Lordship, at least 2 weeks kindly, because this is the
File it within.
800 pages, Lordship. You see, there is the 8 forms.
Very good.
But categorically, we have to.
Heard learned advocates appearing for the respective parties. Full stop. You are Miss Sethia Sarkar. Miss Sarkar, learned advocate appearing for the petitioner. No, tar aage likho. The petitioner has challenged two notices, one being an intimation notice dated March 17, 2023, issued by the Joint Director DGGI, Siliguri Unit, Siliguri Zonal Unit, Siliguri, and the other being a show cause notice dated March 31, 2023, issued by the Joint Director DGGI, Siliguri Zonal Unit, Siliguri. না 3 notices করিনি 2 করেছি না নোটিস ওটাকে 3 গুণ and টা কেটে দিন second and the third being a summary show cause notice dated August 1, 2024, issued by the Assistant Director Siliguri Zonal Unit, West Bengal. Full stop. Mr. Sarkar, learned advocate appearing for the petitioner, submits that Miss Sarkar, learned advocate appearing for the petitioner, submits that the intimation notice that all the three notices suffer from patent illegalities. Full stop. She submits that while the intimation notice refers only to periods between April 18 to November 2022, the show cause notice refers to page
85. Yes.
page 85. Yes. July 2017 to April 21 colon semicolon. July 17 to April 21 years. All of them are same.
Same.
তাহলে colon হবে 2021. And what about the third notice?
Third notice, third notice,
What is it?
Page?
Eight.
6, 7.
Page 26. Yes. And the third notice, i.e. the summary show cause notice, refers to periods from April 2018 to March 2022. 2018 2018 to March 2022. She submits that firstly, any proceeding in respect of a period from the year 2017, financial year or assessment year, what do you say here?
Financial year.
Financial year
Yes.
2017 to what will be time barred?
1780.
That any proceeding in respect of the financial year 2017 to 2018 would be time barred. And secondly, comma, all the said notices are consolidated in nature in as much as they refer to several financial years clubbed together. List this matter. চলে গেছেন?
This matter, I have already supplied the copy to the client, to the opposite part. And I have required the definition of service also, but unfortunately, yesterday, GP. Has told me to serve them personal, physical copy, so I am ready with that because yesterday it was.
We serve today, tomorrow should I keep it tomorrow?
So medical emergency, tomorrow we have to go to there.
Okay, okay,
So let this matter, I think you're on the next something time.
next. লিখে নিন।
And I'll make the-
It is submitted on behalf of the সিক্সটা সেম অর্ডার বুক, সেভেনটা ফলো করুন, এইটটা ফলো করলে অর্ডার যদি কেউ অ্যাপিয়ার করে না।
And 7 I am for the petitioner, my lord.
Yes,
My lord, matter about, my lord, cancellation of my route permit as well as not supply the timetable of my vehicle, my lord.
who is appearing for the respondents?
Lord, I have served. Lord, my junior is there, my lord. Affidavit service filed yesterday, my lord.
Why don't you serve the GP again?
My lord, I have already served, my lord.
That you have already started there.
I am for the statement.
Yes, yes, sir.
My lord, matter about, my lord, not the cancellation of my route permit as well as not issued the timetable of my vehicle, my lord. My lord, kindly come to page 16, my lord, of my writ petition.
1/6.
My lord. That is the offer letter dated 6/11/2024, my lord. That's the offer letter.
Yes,
As per resolution of RTA board meeting dated 23rd February 2024 and subsequent issuance of NOC by RT Alipur Duar Bhait Memo number such and such dated 25/10/2024, my lord. On that basis of the offer letter, my lord, respondent number 2, that is RTA Kuch Bihar, issued permit, my lord, at page 28 of my writ petition, my lord. Kindly come page 28, my lord.
28.
28, my lord, bottom portion, my lord, serial number 9, period of validity, next number of daily single trips allowed 2.
Yes, 2.
2. Trip of
Yes.
daily, my lord, number of daily single trips allowed 2. My lord, route is from, my lord, Mathabhanga bus stand to Joygaon via Kuchbihar, Sonapur.
Name of bus stand is Mathabhanga.
Mathabhanga, my lord. Mathabhanga to Joygaon.
Very
That
well.
is my route.
Yes.
My lord, thereafter, my lord, after issued this permit to the petitioner, my lord, accordingly, my lord, page 31 of my writ petition, I have submitted my timetable on the basis of, my lord, permit issued by the respondent number 2, the RTA Kuch Bihar. I have submitted the, my lord, timetable 31, my lord. Annexer P7.
Yes, yes, page 31. What do you want to show?
My lord, there is that timetable, my lord.
Yes,
My lord, I have submit this timetable before the concerned authority
for
and
approval.
for approval. After that, my lord, then my lord, I have submitted along with my application, my lord, that page P8, page 33 for approval my timetable, my lord.
Yes.
Thereafter, my lord, concerned authority, respondent number 2, issued a notice which I have received on 5th June 2025. In that notice, the authority concerned, my lord, bottom portion of this notice, my lord, now the stage carriage permit number such and such has been rectified as mentioned one trip in the permit by the Secretary RTA Kuch Bihar, and it is notified that the previous copy of the permit is null and void. On what ground, my lord? My lord, before that paragraph, paragraph number 2, whereas a provisional timetable for single trip has been issued by the Secretary RTA Kuch Bihar in favor of Sri Subroto Kundu for flying his bus in route from Mathabhanga to Joygaon via Kuch Bihar, via memo number such and such, dated 27 February 2025. Thereafter, the applicant placed the vehicle for registration and issuance of the said route permit, and the process was subsequently done by the office of the office and the registered vehicle number WB63D020225 and stage carriage permit number WB2025SC0286A for flying his bus for one trip in a day, but mistakenly at the time of issuance of the permit there is entered 2 trips instead of one trip in a day. My lord, absolutely, that is in conspiracy with other vehicle owners and union staff. This notice has been issued upon the petitioner, my lord, without any considered my read, my lord. Thereafter, my lord, kindly come to page 36. 36 of my petition, annex of 10. There has, my lord, number of vehicle number, all these vehicles flying daily 2 trips, but my vehicle initially the authority has issued 2 trips, but after that, after filing that, submitted the my timetable of 2 trips, they intentionally issued a notice by cancelling my permit 2 trips. On what ground, my lord? Only the reason is mistakenly mentioned in his
Yes, sir. How
notice.
could you commit such mistake?
But this is a statement of fact addressed to the examiner.
All other vehicles are flying 2 trips in a day.
Well, just the next page number 1. Well, this is the application. My lord has got.
Yes.
My lord, this is the application made by them. My lord, this is the first application made by them that says single trip for a single trip. My lord, first trip up and first trip down. Their application, my lord. Then the very next page, my lord, page number 2.
No, 1 trip up and 1 trip down means 2 trips only.
No, my lord.
It means
That's
1
one
trip.
trip.
It
2
makes 1
trips
trip.
up and 2 trip down is 2 trip.
So up and down together make 1 trip.
1 trip. Now, my lord, on the very next page, this is their application. 1 trip up and 1 trip down, my lord. Now, my lord, would come to my statement of facts, my lord. On paragraph number 4. The first paragraph number 3, my lord, I'll read it out. The petitioner applied for new stage carriage route permit in the route from
Where are you reading?
Well, paragraph number 3 on this page, the very first page.
Yes.
The petitioner applied for new stage carriage route permit in the route from Mathabhanga to Jaigaon via Kuch Bihar. After granting the application in RTA board meeting held on such, the Secretary RTA Kuch Bihar sent a letter regarding issuance of NOC from RTA Alipurduar, and subsequently the Secretary RTA Alipurduar replied with his letter via memo such and such dated 25/10/24, mentioning that the NOC given subject to clash-free timetable from RTA Kuch Bihar. This is the NOC part. Now the main part is the 2 trips what we have issued, that was a clerical mistake, because their application says first trip up, first trip down. Second application says first trip up and first trip down. So we have, if there is a clerical mistake from our end, we have issued that in 2 trips. That was been rectified by our order on the 27th of May. Now they're saying since you have issued that on the second trip, now once the application also was made on the first trip, now you cannot change it. They cannot be take advantage of our clerical mistake from our end, which we have already rectified.
Yes, sir. When you yourself have asked for only one trip, why do you bank on their saying two trips? Your request
My
is
lord,
for one trip only.
my lord, that is also mistake on my part, my lord, petitioner part, my lord. My lord,
So your
kindly I have
mistake you will
clarified.
ignore, their mistake you want to
My
highlight.
lord, my lord, kindly consider my application, my lord, page 33. I have clarified how I have mistake my lord on trip, my lord, page 33, my lord. I have clarified in my application representation dated 28th May, my
But
lord.
sir, this clarification of yours at page 33 comes after this letter was issued. This was
No, my
also
lord, before
on the
that,
same
my
day.
lord, this letter I have received, my lord, on 5th June, my lord. But I am submitted 28th
So
June,
that
my
is
lord.
the noticed on 27th May.
It has been issued on 27th May only. You might have
But my lord,
received.
I have received, my lord, on 5th June, my lord, 5th May, 5th June, my lord, 2024. I have mentioned in my credit application, my lord. They have supplied, my lord, on 5th June 2025, my lord. I have mentioned in my application paragraph number, my lord. Paragraph number, my lord. My lord, 12, my lord. Paragraph number 12 of my writ application. That your petitioner states that thereafter on 5/6/2025, respondent number 2 and 3, that is in collision with respondent number 4, 5, 6, 7, and 8, and their other men and agents by a criminal conspiracy have issued a notice at memo number MV 569 dated 27/5/2025 at paragraph number 5 stated that, but mistakenly at the time of issuance of the permit there is entered 2 trips instead of 1 in a day.
No, sir, you are not right. You please come at page 33.
My lord, 33, my lord.
Your submission doesn't seem to be right. Page 33, your mail is of what date? 28th of May.
20th May, my lord, at night,
28th,
my lord.
please
12,
let me
16.
complete. Let me
12,
complete.
16, my lord.
It is 28th May, 12:16 AM, right?
Yes, my lord.
Yes. Now come to the last part of your mail at page 33. Thereafter, on 27/2/2025, you and your good self issued provisional timetable vide memo number such and such as per order dated such and such. And you have referred to everything. 19th May, 20th May. Now I have come to know from reliable source that you and your good self may issue timetable for single trip only. What is the basis of this? This is immediately after issuance of the 27th May, this notification that you have apprehensions. Why should you apprehend? What is the reason for you to apprehend?
My lord, because my lord, before that, my lord, number of my lord representations, application, objection submitted by the union, concerned union authority, my lord, kindly page started from my
This
lord.
does not appear to be
18.
that easy.
My
This
lord,
does not
kindly
appear to be that easy.
my lord, kindly consider my page 18. Since page 18, number of my lord secretary of the union, concerned union, objected.
I cannot immediately set this aside. At best, I can call for a report or ask them to file an affidavit because this.
Oblige your lordship. My lord, one thing, my lord, if my lord, all other the vehicles is flying 2 trip in a day, in that case, why might vehicle only one
Because
trip?
you have requested for one trip.
No, my lord, that is my
Yes.
mistake, my lord. That is my mistake. I have clarified in my.
No, they have also committed a mistake.
My lord, grateful, your mercy. Report, my lord, may be submitted by the respondent authority, my lord.
No report. I am asking for affidavits because report.
Yes, my lord. Yes.
Already submitted report.
Oblige your lord.
Yes, sir. Next.
My lord, date may be fixed, my lord.
Date I cannot fix because I don't know. After expiry, it will appear before the next circuit bench.
Oblige, your lordship.
How can I fix a date? Because we don't know when circuit bench will be sitting, when it will not be sitting.
My lord, you mentioned next circuit bench, my lord.
Yes, that I have mentioned.
Okay, grateful, your lordship.
Lordship, I request to pass similar order as
Yes.
item 5.
ওই একটা adjournment এর prayer করে
Dadash. Grateful.
In item number 9, I am appearing, your lordship, Ratan Bolik myself, on behalf of the respondent.
Lordship, can you think
Item number
the
9.
matter next week? The advocate on request
Next
not
week.
take-
There is a prayer for adjournment, not this week.
In
Not
that
this week.
case, kindly
Not-
fix it Tuesday, your lordship.
Not this week, it will appear on Monday.
Grateful,
If you have any problem, you make a request, I'll adjourn it to Tuesday.
Grateful.
My lord, I am appealing for the petitioner. My lord, this is a matter, my lord, at the very nutshell, lordship, this matter, my lord, subject to your lordship's kind consideration, is to be heard, my lord, by exchange of affidavits. Because lordship, the matter in a very nutshell is this: the petitioner is a PSF personnel since 2002. My lord, he promoted different times, and presently, my lord, he is posted as second in command in subsidiary training center situated at Siliguri. My lord, he performed in different sensitive places like Barmulla, Kashmir, and all that. And my lord, as per their DOPT norms, my lord, the self-appraisal is needed to be submitted for, my lord, preparations of the APAR, which is annual performance assessment report. My lord, he submitted. But his APR, my lord, no communications on the part of their employers with regard to the APAR. Subsequently, he searched it online, which is in their website, which is called eSparrow, and found that his APAR has been downgraded for the year 2020 to 2021. He made several correspondences to the higher authority, and he exhausted all the remedies, and it has been refused by them. Although the fact remains, my lord, there are the number of pronouncement of the Honorable Apex Court and the Honorable High Courts that if the assessment has been downgraded or the APR is downgraded, that has to be communicated. Because if it is not communicated, the incumbent, the employee will not be able to understand why it has been downgraded. He could not rectify what he has done. So, my lord, the communications is necessary. That has not been done. And the refusal letters by the authorities, they have stated nothing with regard to the non-communications of the APAR. So, lordship, I think lordship kindly comes to the last order. That is in page 53. He even requested for a personal interview. That was also rejected. So, my lord, it's a gross violations of the principle of natural justice and their own notification that is there in my hand. My lord, where it has been stated that communication, the personal communication has to be done.
And where is the document by which your APR was downgraded, you see?
My lord, this is the first one. Lordship kindly comes to page 29 onwards. Your lordships will get it, the numbers. That is in page 37, 35 onwards. 35 onwards, 35. Lordship kindly comes to the bottom portion, 5.63. It is good. Huh. And the final list is page 38, that is 5.75. Now, lordships, it is downgraded. Your lordships will understand from the APAR of 2021-2022, which is also I have annexed in my petition. The subsequent APAR.
Page?
My lord, the first one.
No, the
The subsequent one. Lordships will get it from page 54 onwards of my petition. And the grade is, the number is, Lordship, the last page, 62. Where it is 8.27. Page 62, bottom, Lordship, left side bottom.
Page 62.
Yes, your Lordship. Let's 8.27. Lordship has got it.
Yes, 8.2.
8.27. My lord, even that, my lord, in earlier years, since 2002, my 2000, my lord, he's all the appeals of the
So these,
petitioner.
These gradations are justiciable. If they have downgraded you, you don't have any avenue in the department to challenge it or.
Yes, my lord. My lord, we have done everything that is, Lordship kindly comes to page 39. A detailed, comprehensive representations on the part of the petitioner.
Yes, this has not been considered or
Considered and rejected. That's why, my lord, my first
Rejection is
page 49, Lordship kindly comes.
page 49.
Yes. This is the remark of the competent authority, my lord, without any reason. That is what I am submitting at Lordship kindly see, page 49. The representation is rejected being devoid of merit. So no reason, nothing with regard to the non-communication of the downgraded APAR, which is the must as per their own notifications.
Where is that notification? What does that say?
Well, notifications and Lordships kindly comes to the notifications that communications of the adverse or the advisory remarks is to be done.
No,
The Lordship kindly comes to paragraph 2 of 2. However, as per the instruction issued by later circular under reference, the portions of adverse or advisory remarks should be communicated in verbatim, duly underlined, and specifying the nature of the remark, whether these are the adverse or the advisory, instead of writing adverse. So, my lord, whatever it may be, when it is downgraded, it has to be communicated. My lord, thereafter, even, my lord, we made representations, that is in page 50, to the Director General of Border Security Force. Lordship kindly comes to page 50 onwards.
Page 50. Yes.
Request for personal interview, redressal of grievance, that is rejected, page 53. There is also no reason as such.
Where is you have this circular of 11th of September 2015, which has been referred to in the document at page 53.
That we could not collect, my lord.
Yes, sir.
Lordships.
They are the number of judgments of Lordship knows better than me. Jal Nigam and the Devdatta. Today I do not have it in my hand. Lordships kindly.
Let me hear them. Let me see what.
Yes, yes.
Lordship, the judgments are taken up, then first of all, they have to show your lordship that the order that has been passed offends Wednesbury principle, that they have failed. Until the conscience of the court is shocked by the action taken by the department, a writ court will not interfere. This is the first parameter. Secondly,
The only thing which troubles me, sir, is if you see the order.
Well, my lord, I've seen they have only showed your lordship the last line, but the earlier lines are there. Their earlier orders also there. We'll place it on record. So if my lord allows us
this order does not appeal to reason. Actually, it does not even show reasons because
My lord, that
online-
is the face. If somebody is swimming in the river, the face is only showing that.
Fine, Lordship, page 49.
তার আগে
The order.
সমস্ত কমিউনিকেশন গুলো হয়, রিমার্কস গুলো চাওয়া হয়।
Have they finished, my lord?
No,
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 no, you
you're,
say, you tell me.
No, my lord, it is only the face. We will demonstrate before your lordship that how the order came into being. My lord, natural justice is not such a thing that it has to be everywhere present, but we have to show that it has been obeyed. He was
If you can
heard.
show from the records that yes, reasons are available, then court can take that into cognizance that I am aware of. It may not be there in the order, but it should be there somewhere from where it can be deciphered.
Right, my lord, let us read the order first.
It cannot be a case of reasons being non-existent.
Lordship, their order, their grievance is ordered at page 49.
Yes.
I have carefully gone through the APAR, the representation of the officer and the comments of the IO. I found that the RO and the accepting authority in this case could not endorse their remarks because of their demeting office and superannuation reputation respectively. The initiating officer objectively assessed the performance of the officer during the period under report. Considering the matter in its entirety, I do not find in the merit to interpret the remarks and assessment endorsed in the APR of the officer. So this is an
So
appellate order.
what is important here?
My lord,
is
this is
the-
an
is the
appellate order.
remark-
This is not the first order. This is the order in appeal.
42 আর 43 পেজ রেফার করো।
And where is the first order?
42 and 43
Oh,
রিপ্রেজেন্টেশন হলো 39 এ,
Lordship,
order,
they filed an
officer,
39.
report.
এবার 42 to CR সেকশন রিমার্কস আগে কল করো।
হ্যাঁ, এটা
CR সেকশন কল করো।
Now 42 is the first one.
রিমার্কস অফ দ্য CR সেকশন।
Remarks from the CR section.
Then 43 remarks of the reporting
বললে
authority.
পড়তে দেবে না, আগে সব ছুড়ে ছুড়ে জসাই ফেলে দিল।
না, বলুক,
Page 42.
বলুক না।
As per BSF APR procedure and instructions to 2012 APR of the officers of the rank of
order
White
has
Sea
very much.
may be used to be uploaded in data server of the IPC for communication by respective items, accepting authority.
This is
After
the order.
introduction of each
Talking.
sparrow and as per his order for generation of APR of all officers from 2021 onwards, with the electronic system in place, the recording and movement of power forms become seamless, quick and convenient due to inbuilt area. He was communicated that is from the see Sanjeev Kumar 2IC has checked his NIC mail on after the gap of 6 months and has preferred a representative. And so my lord, he was communicated, he did not check his mail.
My lord, this is not this is not a communication because lordship,
Yes, they say. that
my
the
lord,
system-
this is, yes, your,
Please read page 42,
yes, my lord,
first paragraph,
yes,
last line.
yes.
The system provides status check so that officers know
They
their PARs are.
are, my lord, this is their stand that they have uploaded the APAR to their official website. The petitioner did not check, but this is not the system, lordship, that has to be communicated to the petitioner. When the communication has not made, petitioner waited for a long, thereafter he checked the website and found his.
Them use their affidavit.
And these are
The
the,
petitioner complains বোর্ড টোড আছে বাইক কিছু, তাহলে তো সবাই দেখতে পাবে, একটু ওয়েট করে নিন, পাসওয়ার্ড করে রাখুন।
Mother 12 I appear on behalf of the petitioner.
Yes.
In item number 11, my lord.
11 was passed over. Let me hear 12.
As you lordship.
So 12 not 13.
12.
12 my lord, I appear on behalf of the petitioner. These are the three, my lord, the oh, oh. If your lordships kindly turn this is in respect of the, my lord, the approval of headmaster from the post of the teacher in charge. By the judgment of the coordinate bench, my lord, the GT authorities had taken a regulations that the teacher in charge having qualification.
Just a second, yes. Mr. Bari, you are appearing for? Kolkata.
1, 2, and 3.
So the respondent numbers 1, 2, and 3 are represented by a learned advocate. It is said that copies they have not yet received.
Very well, my lord, your lordships keep it on Monday. We have already forwarded. Again by email I can forward, no problem. Keep it on Monday, I shall do it.
Monday it will be okay, madam? Learned advocate appearing for the respondent numbers 1, 2, and 3.
বলুন Monday ঠিক আছে। কি বললো সে শুনতে পাবো না। ইমেলে পাঠিয়ে দাও। হ্যাঁ করে দাও। এগুলো কি? হ্যাঁ কি বলছি?
13th of হয়ে যায় একই আছে।
মানে item 13(6)
Same.
should I?
She says she has not been served. 13 also.
Yeah, no, all have been forwarded. He has not received it. Anyhow, my lord, we shall make it further. 13, 16, 17, 18.
All three. Here. 13, 16, 17, 18.
19, 24, 25.
16, 17, 18, 19.
24, 25. These are my lord.
Please wait, Mr. Bari, please wait. It will be
Yes,
confusing.
yes.
Please wait. One by one, let it be called, then we'll make the same prayers. We'll record the same order.
Wait.
Call Passover matter. No, if you give all your numbers, otherwise they will not be able to match as to which serial number. That you can do.
1286 দিয়েছি, এটা 87 13 নম্বর।
12 and 13 হয়েছে। আর কি হলো? 16, 17 হলো না?
I'll just get back.
11 টা একবার কল করে দিন।
I'm for the petitioner, madam.
Yes, madam.
My lord, led by Mr. Bodurjo Ghoshal. My lord, in this matter, there is a huge mistake of calculation, my lord. In this matter is about that the petitioner is a owner of a emart shop, my lord, and he inherited the business after his father's death, my lord. The license was transferred to his name in March 2021, my lord. The initially petitioner distributed the rations using his father's official ID, and then the new ID was issued in the petitioner's name on 18th of October 2021, my lord. And there the problem arises, my lord. The core issue involves in this matter around these discrepancies in the stock balance, allocation and deduction made by the department, my lord. And the petitioner claims that from June 2022 and in 2023, same month, that is in June, the department deducted the allocated stock from his portal without prior intimation, my lord. After that, in August 2024, the petitioner received a receipt showing a marged balance. My lord, in that marged balance received, no no figure has been mentioned by the department that as to how much stock has been deducted from the petitioner. No, nothing has been mentioned, my lord, in this matter. So after that, furthermore, from November 2024, my lord, the departments began spontaneously deducting 20% of each ration card categories stock from the petitioner's portal, my lord. This deduction is ongoing and is an attempt to reconcile a discrepancy between the petitioner's EPOS machine and his deceased father's portal, my lord. The petitioner argues this adjustment is being made without disclosing the accurate amount of the stock, my lord, which needs to be adjusted. So additionally, my lord, the petitioner states that allocation for December 21 and March 2022 were merged, and he only received half of that total allocation.
So you want to get access to the portal to correct the
Yes, my lord.
mistake in the stock balance?
My lord, consider the representation along with the demand of justice notice, my lord.
Why don't you consider the representation and dispose of? Consider the representation.
My lord, in the meantime, when there was a process of merging the balance, my lord, mistakenly department has deduct the stock of Amit Das from the account of RN Das, where the card number was different. His father, Amit Das, petitioner's father's name was RN Das, and he bearing the license number, last 2 digit of the license number was 95. And the department deduct the stock from the account of RN Das, where his last license number, 2 digit license number was 79. So that all.
So that also you must have made.
Yes, my lord, in the demand of justice notice.
So
my
they will
lord.
consider that and they will pass appropriate orders or take
Grateful.
appropriate steps, whatever it is.
My lord, the
Mandatory.
My lord, may I request your lordships, my lord, the order need not be recorded. Your lordship simply note this week. In the meantime, whatever steps
But
taken, I will do it.
I have already passed an order. She's
No,
there.
your lordships passed an order on 12. Let it be remain other matters. So far other matters are concerned, your lordships keep it.
Order is required.
No, she says that she'll have to get a copy from the department, so an order is required.
Now we
Let
have
an
already
order be
forwarded
passed.
to the department, no problem. And then in addition to that, I can by email I can.
An order will benefit other persons in other
Oh,
ways. also.
very well, very well.
Yes, yes, that is there. Order is same order record করলে অসুবিধা একটা প্রেজেন্স হবে তো ওদের না অসুবিধা You give your names.
Yes, I have given.
Malal, let it be Monday in a bunch. Let it be Monday in a bunch. One order it will cover.
Yes.
No, orders will be separate. They'll be separately.
Yes, yes. Let it be
because
taken together.
It will be taken together.
Sir.
13, 16.
Then item 13 হয়েছে
16.
Copy sent to be email.
13 হলো তো এবার 16 টা করে দিন 16 সেম অর্ডার
Same order. 17.
এগুলো সব সোমবার থাকবে
হ্যাঁ
এগুলো সব সোমবার থাকছে সোমবার লেখা আছে তো
Same order. Same. এই তো 20 কি আছে 15 হ্যাঁ কত
At least one appearance you have got. You are aggrieved in the morning because you are not getting an appearance.
24, 25 same.
Yes. চলুন এবার সিরিয়ালি কল করুন এগুলো সব সোমবারে থাকবে
49 for the petitioner. I for the petitioner.
Yes.
Matters pertains to fair price shop license, my lord. My lord, here is my affidavit of it.
Yes.
My lord, upon a notification of invitation dated 13/5/2024 by the my lord subdivisional controller of food and supply Dinhata, my lord petitioner filed his application for a FPS dealership on 22nd of August 2024. My lord, thereafter verification has been done by the respondent authority and my lord interview was done and my lord in the interview only the name has been called of the name of the petitioner has been called and asked them to go home, my lord. My lord, the specific allegation is that if your lordship kindly comes to page 26, my lord.
Page 26.
Page 26, my lord. Point 4, requirement of size of godown and shop of running of a ration shop. My lord, for panchayat area. For panchayat area, my lord, the boxing. My lord, it must be in the space of minimum 30 square feet along with the covered space 100 square feet adjacent to the godown to be used for the purpose of weighing and for the operation, my lord. My lord, the respondent number 7 has been selected as a most suitable candidate. But my lord, his godown and my lord, his shop is not adjacent to each other. His godown in another place and my lord, the shop is another place. And my lord, whereas the petitioner shop and godown adjacent to each other. If your lordship can do page number 44, it is my sketch map of the my lord godown and my lord the FS shop. My
Page
lord,
44.
page 44. My lord, the sketch.
Who is appearing for the private respondent?
Yes, they are required.
No one is
Private
appear.
respondent will be required. You
My lord, I
have served
served the yes, my lord. Affidavit of service, my lord.
them. Affidavit. আছে। The private respondent has already been allotted.
Yes, already selected for the.
I don't. So far my instruction, he has been selected, my lord.
They have also stated.
Selected.
They have also stated in the read petition.
Is selected. Whether license has been allotted or not, I don't know.
License given.
Probably. No, not it given, but he has been given on the basis of the selection process.
Yes, my lord.
It has, private respondent has not been served.
My lord,
His addressee cannot be located. See affidavit of service.
my lord, let there be direction upon then, my lord, the state to serve them because
Why you will serve?
because
No,
my lord,
but
what address I have served upon them. And if because my lord, the address is incorrect, what could I do, my lord? I have no other option other than the
Address is
poster.
sufficient. If you have address, please provide particulars of the address.
We are carrying this address only as per the application.
No, she must be, if she has applied, she must be having the address.
And that address has been provided by the petitioner. She might be residing elsewhere, that we have no idea.
If my lord, she is residing elsewhere, then my lord, the case is
Maybe.
more interesting, my lord.
You try one more time, let us see what happens thereafter. Service on the respondent number
Good.
call one more RF to call.
15, I represent state in this matter.
Petitioner,
Mr. Bari.
not today, Kori. Not today.
Lordship, there are similar matters, 15, 20 and 23.
Let us see if he comes 20 and 23. ঠিক আছে তাহলে পরে পাস ওভার করে রাখুন দেখি যদি হয়ে যায়
Passed over, Lordship.
পাস ওভার
Great.
see if he comes for the other matter.
No.
So we'll meet after recess.
Great.
My lord, the matter is conducted by Advocate Ikramul Bari. So will appear physically on Monday. Kindly, if the matter be fixed on Monday.
তাহলে not this week করে, not this week.
Not this week.
Not this week.
Yes, 15, 20 and 23. Monday. 20 and 23. 23. Grateful.
Very well, I'm making it not this week only, not this week.
My lord, Monday. Not
21 also,
also.
not this week. Yes.
My lord, praying for not today because Bhaskar Rai Mahasaya will appear in this matter, my lord. Only not today, my lord.
Not today.
Great, sir.
এই not today, not this week এর সব পাঠিয়ে দেন আমার সাথে, যেগুলো আজকে টাইম হয়েছে পড়ে আসবে তুমি। হ্যাঁ, সব পাঠিয়ে দেবে।
My lord, in item number 26, I am appearing for the DPSC Kuch Bihar, my lord.
Petitioner,
Your senior counsel is supposed to appear in this matter virtually.
nobody is there.
মৌসুমি দাদা মৌসুমি যেটা আছে ওটা ওটা he is here virtually, lord.
Yes, madam, who is appearing?
My lord, I am appearing for the DPSC Kuch Bihar, my lord.
Who is appearing for the
Respondent
petitioner?
number 7 and 8.
Not today করে দিন।
Your lordship, kindly make it not this week, my lord.
Not this week.
Kindly take up the matter on Monday, my lord.
All right, not this week.
Not
Not this week.
Yes, my lord. My lord, item number 27, 28, identical matter, my lord.
These are similar matters, lordship.
You are appearing?
Yes, my lord, I am for the appearing, my lord. Rohan is appearing for the conducting advocate, my lord. Ali Hassan Alamgir.
You are for the petitioner?
Advocate record, my lord, but the conducting advocate from Kolkata, he will appear virtually. my lord.
Nobody is appearing.
Can wait tomorrow, my lord?
Yes, I can have it at tomorrow. Tomorrow.
My lord, Monday, my lord, identical matter, my lord. Item number 26, 27 and 28, my lord, similar matter.
ঠিক আছে, তাহলে Monday. Not this week. দেখি কি ম্যাটার।
এই পৃষ্ঠা নো
nobody is appearing. একটু order record করুন তো, none appears for the petitioner. Full stop. The day.
Great.
I'm praying for not to the lordship.
30, my lord, I am for my lord the distribution company limited.
Tomorrow? Not today. All matters not today. Why? What has happened?
Now, my lord, in this matter, my lord, lordship may take up the matter next week, my lord. Kindly pass an order. Instruction is required, my lord, because my lord, the petitioner, my lord, is the wife of the one of the employee. My lord, she has approached before the my lord magistrate court, my lord, and got an order under section 125. Now, my lord, this is a hard prayer in this writ petition is that we shall deduct the amount of maintenance, my lord, and pay it to her, my lord, unless there be a direction for attachment of the salary of my lord, the concerned employee, my lord, we cannot do that.
No,
and next,
you
my
cannot.
lord, next matter, my next fold of the prayer in this writ petition is that, my lord, her
All right,
allegation
she's seeking for an accommodation today. You make this submission tomorrow, I will consider it.
my lord, my lord, my lord.
Not today. Yes. Madam, be ready tomorrow. Don't pray for time. Yes.
31.
I'm praying for short Passover, my lord.
Passover.
32.
So I'm praying for 1 day accommodation, lordship.
Not today.
No accommodation. I'll do it today. I appear for the petitioner. May I, my lord?
Yes, please.
As it pleases, my lord. My lord, the writ petitioner was initially employed under VRP in the month under the scheme of Manrega in Panichala 4th Primary School on the 12th day of July 2005. My lord would find it annexure P2, page 15. And primarily he is of scheduled caste, which is annexure P1.
Yes.
Yes, my lord. Subsequently, my lord, and he has met with qualifications of being employed. The list of qualifications is as annexed P3 from page number 16 to page number 20. All the mark sheets from class 10 to 12 to the college education and the BLEd and DLEd, my lords. My lords would find it from page number 16 to 20, my lord.
Yes.
Subsequently, my lord, an allegation was brought in the year 2010, whereby for some days he was suspended. Later, that matter was referred to Lok Adalat, and that matter was compounded. And the matter was set aside, and he was reinstated. My lord would find the Lok Adalat's order on annexure P4, page number 21. Subsequently, my lord, in the year first day of July 2012, from Sarva Shiksha Mission, he was employed. He was given an employment till he attains the age of 60. My lord would also find that at page 22 P5, annexure P5.
Yes.
Subsequently, my lord, on the 9th July 2016, there was again some political rivalry and allegations were made that of harassing a fellow colleague, and a verbal suspension was made, against which several deputations were made, which my lord would find from from annexure P6, page number 23 to 27. Subsequently, my lord, due to this verbal suspension, no show cause was given to him, and he was arbitrarily suspended, stating that please do not come from tomorrow to the office, or else there will be some political rivalry and there will be some scuffle that might take place. So please stop coming to school. Subsequently, my lord, we had made an FIR 2 after all our deputation fails, and my lord. Yes, my lord. And as because everything failed, my lord, yes, my lord, one notable thing, we were given an for booth officer. We were during this verbal suspension, we were given this duty of booth officer, which my lord would find out from page what was the copy of annexure P8, my lord, from page 28.
What is your immediate grievance?
My lord, my immediate grievance is, my lord, kindly restores my right to be employed, regularize my salary, my lord. Because everything comes up here as a verbal, and during the suspension, my lord, I have been wasted with duties of booth officer.
Yes, sir. Who is appearing for the state authorities? You are appearing. What is your? When will you be ready with the instructions? Learned advocate appearing for the respondent state authorities.
My lord, obliged, my lord.
ওখানে 2 weeks টাইম করে দিন, তাহলে নেক্সট অ্যাভেলেবল সার্কিট বেঞ্চ এমনি হয়ে যাবে। 6 সাম টাইমটাকে 2 weeks করে দিন। Then it will be covered.
Yes, yes. Or else if my lord keeps it tomorrow and keeps it on the next week, then they will again say that they will require time.
Yes.
So 2 weeks.
So 2 weeks.
My.
I have recorded that you have played for 2 weeks this time, so I am fixing it. देखिए none appears for the petitioner. Full stop, no.
Lordship, here I am appearing on behalf of the appellant petitioner. This is being led by Syed E. Huda, who is appearing from Kolkata.
Yeah, I appear for the petitioner, my lord, in this matter. My lord, the petitioner, my lord, is an FPS dealer, my lord. In short, my lord, he is a ration dealer, my lord, catering to his beneficiaries, my lord, within his jurisdiction. My lord, what has happened is the state, my lord, has issued a notification, my lord, whereby, my lord, my beneficiaries, my lord, the units that I serve to would be curtailed. So, my lord, I have challenged the vacancy notice one and with certain guidelines. Now, my lord, similar to this writ petition, my lord, at least more than 50 applications have been filed before, my lord, the regular bench of the High Court. And in all the matters, my lord, one, my lord, same order has been passed, where, my lord, I have not prayed for any interim order as of now. So, my lord, Lordship, my lord, my junior, my lord, has the sample order. Lordship can pass the same order, directing them, my lord, to file a detailed report in the form of affidavit, my lord. That's the order that has been passed in all the matters.
Lordship, I am presenting the affidavit of service.
Where is that order which your learned friend is referring to?
Lordship, it has been reported in the affidavit of service, I hope so.
No,
Because
order?
no, affidavit.
No. It should.
He is not ready with the order.
Lordship, kindly takes it up tomorrow in that case, my lord. I'm very
Not
sorry, my
today.
lord. This is very embarrassing, but kindly takes it up tomorrow.
Not today. Not today.
My apologies.
Your Lordship, kindly praying. I'm praying for not today. The senior counsel engage in principal bench.
Tomorrow he'll be available.
I think tomorrow it will be.
Not today.
Your Lordship, 37, 38, the same.
37, 38 also.
Same senior counsel is engaged
Not
in
today. Kore.
36, 37, 38. 37 or 30?
36.
36, 37, 38, the same one.
Same. Not today.
Not today.
36, 37, 38. Not today.
Additional advocate general is appearing for the state parliament. It is short Passover. He's on late.
Passover.
My Lord, 40 I'm praying for Monday. Advocate Ikramul Bari will appear physically and
Not this week.
grateful, man.
देखिए none appears for the petitioner. Nah, respondents are also not.
Actually, one day accommodation also.
Not today.
43. Yes,
Hello. 43, Mr. Subropoka's diary is appearing online. That's right. 43.
Nobody is there.
Let them not today only.
Not today. He's not there, not today. Let us see tomorrow if he appears.
Grateful.
Yes, madam. The issue is here.
Not I beg to appear on behalf of the respondent number 7 and 8.
Order passed on 12/2024. There was a direction upon the state to inform if it is not because the rank of deputy secretary, Department of Urban Development and Municipal Affairs. The Department of Urban Development and Municipal Affairs is not a party police service.
I just say why. My lord, issue is, my lord, whether sanction of the building plan is required under municipal law in case of construction in the principal market year of, my lord, agriculture market. We have made the state government party. You also can see that number one, the principal section, because what happened? The petitioners have challenged a construction done in a principal market year of Shiruli Regular Market Committee.
Just a minute, just a minute.
Not,
Last page of the order.
Even irrespective of whether such person was made party to the writ petition or not, if a direction is passed, he has to comply with it. He was asked to file an affidavit, whether he is made party or not, how does it matter? He is a state functionary. He's a state functionary. If he has
They
been
have
asked
taken
to
this
file an
plea now. After 4 times adjournment, they have taken this plea.
because in the last order also it is recorded that counsel for the state seeks and is granted 2 weeks time to file affidavit in opposition.
The last order, we see that there was already a direction from an affidavit.
You should have seen this earlier also, because there is another direction on 28th of April 2025.
So Secretary Agriculture and Marketing Department is the
Is because I've challenged the order of the DM as a chairman of the market committee. My lord, they can bring it. Now they have taken this point. State is a party there.
Yes.
The issue is, my lord, whether issue is very in general issue. Issue is whether sanctioned building plan is required under municipal law in the principal market year of the regulator market committee. This is the issue. Apart from the other issues. No, my landlord has taken this plea, but that was not taken earlier. This is adjourned on this ground for on several occasions. Your Lordship, but the improved order?
Yes, what is the problem? What is the order here which is
Yes, I am saying, madam. People also, madam, your Lordship knows that there's under Original Agriculture Marketing Act, there's a principal market yields. All over in West Bengal, in Siliguri, there's a principal market. Those are under the Original Agriculture Produce Regulation Act. Here the petitioners are, this is the second round, madam. The petitioner, they are also stallholders there. They have challenged the further construction in the market years without sanction of building plan, and other points are also there. The first petition, they have raised the question local standard that was not taken. Justice Sarkar was pleased to pass an order. If you logically come to the order, this is my page 49. Start of page 49, my lord has formulated some issues at page 52. As 52 is the relevant portion, my lord. It starts from 49, 52. There are many points, basic fundamental points, whether building plan is required or not. My lord, then my lord, they pass a reason order. It starts on page 55. And can you see apart from other points, can you come to page 63, point F. This is the issue here now. Page 60, point F. Hello.
Page?
Page 63. These are, they have dealt with the DM dealt with, but I'm now only point F, page 63. Whether the plan for the subsequent construction has been approved by the City Municipal Corporation or not. This is the issue. Got it, on page 63.
Yes.
Now I just place it. With regard to the above point and taking into consideration the objection raised by the petitioner, in the instant petition under paragraph 13, following objections are given. The Siliguri Municipal Corporation did not say anything specifically regarding requirement of any permission for the state stall in question. In this context, the Chief Executive Officer, West Bengal State Marketing Board, erstwhile State Marketing Board, by memo number conveyed to the authorities regulatory market committee in West Bengal, the opinion given by the landed legal remembrance West Bengal, which says that Section 393 of the Calcutta Municipal Corporation Act provide that no building shall be erected without approval of the building plan in the territorial jurisdiction of Calcutta Corporation. Similarly, Section 203 of the West Bengal Municipal Act is extended, but the safeguards has been given to the erection of government building or government land by virtue Section 3 of the Government Building Act 1989 to the effect that nothing contain any law or enactment to regulate the erection of building within the limit of the municipality shall apply to any building used for the public service or public purpose to be erect on the said land, which is the property of the government. The Act 89 has not yet repealed by any municipal law as referred above. Therefore, it can be said that restriction to erect building any municipal area would not apply in case of erection of government building on government land. However, as per Section 4 of the Act, the authority of any municipality may inspect the land building plan and can offer appropriate measures required to be taken. In such cases, the above convention clearly says that no building is required to be submitted. No building one is required to be submitted to any municipal office corporation for sanction of building plan. Hence, 64 stalls in question are constructed by government body using government fund and government land. But this is the my lord point. This issue is involved. So my lord point is that whether building plan is required or not in a principal market here. This is the issue, my lord. My lord, they have relied upon that Government of India Act at page 68. I can see page 68. They relied on the Section 3. Nothing containing any law or enactment for the time being in force to regulate the erection, re-erection, construction, alteration, or maintenance of building within the limits of any municipality shall apply to any building used or required for the public service or for any public purpose, which is property or in the occupation of government, or which is to be erected on land, the property or in the occupation of the government, provided that while the erection, re-erection, construction, material structure, altering the building, apportion not being a building.
Yes, I have gone. The question is whether
this principal market area,
this is a government building or not. No. That is the only question, which is why the affidavit of Deputy Secretary of the Urban Department, Secretary of Department of Urban Development and Municipal Affairs was asked to file an affidavit. It was to answer this question only, because I have seen that is the noting. Yes, irrespective of whether he is a party or not, how does it matter? If he is not a party, he will not file an affidavit. If his court has asked.
Now, my understanding is this question last 4 times that took the adjournment on this.
This is not a ground.
Well,
He has to be implemented as a party.
Why? Court cannot pass any order on the government authority. If the state is a party, state of West Bengal is a party.
Yes. He has to represent someone.
He is not to represent anybody. He will be filing affidavit in terms of the directions passed by the court, isn't it?
It's a general
was
question,
the state
man.
not represented on that day? On 12th of June 2024, was the state not represented?
Yes.
State was not aware that it was not a party then. State became aware after 1 year. It doesn't augur well to make this submission today after about 1 year. It's almost 1 year, 12th of June 2020, more than 1 year now. We are in July 2025. Today this submission is being made. How can this submission be countenanced? State should have been aware 1 year back also that it is not a party. Immediately, if this had been pointed out, he would have been directed to add him as a party, and this point would no longer have been available to you today. So this does not seem well, does not go down well. Why will he not file an affidavit? If the court has directed, then it is his duty to comply with the order of the court. If you are aggrieved, if you travel up, that why has the court directed if I am not a party? This is not right. For 1 year, the matter has been unnecessarily kept pending for somebody's affidavit. Ask him to file this affidavit within a week, peremptorily. He has to comply with the order.
Yes.
It cannot be, it cannot go uncomplied.
This is I also told my learned friend that, yes, then I'm checked up. This is why I went to state government, because I can't do party to him, because I'm concerned with the subject matter in the market
And
committee.
you today only on your oral prayer, you add him as a party. Let us see, let this ground also go.
Yeah, yes.
Since it is being taken after 1 year, I'll record that.
Yes. No. My lord, the particular person I have just
Yes.
make him
Uh, it is surprising that
Thank you, ma'am. করে দে, হ্যাঁ? নগর উন্নয়ন হবে। এভাবে জানিস তো নগর উন্নয়ন হবে। Yes, ma'am.
My lords, for 45, I appear for the petition. My lords, in this case, this is an income tax case. I had challenged the 148 AD order. No interim order was granted to me. Subsequently, the proceedings I participated and an adjudication order was also passed. And I have also preferred an appeal. So I would like to withdraw this writ petition. My lords, kindly keep all the points open. I want to file my effort. Sorry.
You have a letter from your.
No, my lords, I'll get that if my lords want.
Get it. You get it. I'm making it not today.
Yes.
Tomorrow you get it.
My lords, kindly take this on record.
I'll take it tomorrow. I'm just making it
Very
simply
well,
not.
very well.
You withdraw it tomorrow on a letter. That is better for all of us.
Yes, my lords, yes. Yes,
Bring a letter, I'll take that.
yes. 46, my lords, is the same income tax matter. 148 AD order was
You want to
passed.
withdraw?
No, I don't want to withdraw here. My lords, मेरे को बोलने दो और फिर बोल देना. Here, my lords, what happened? Adjudication order was passed. I prefer a CAN application, asking for a stay of the CAN application till this matter gets disposed. Against that CAN application, they wanted to file an affidavit. That affidavit they have been taking time from last 2 circuits, my lords. So, my lords, this matter can be heard and decided. This is my most humble prayer.
Lordship, 1 week's preemptory, because your lordship.
Let it be heard, my lords. I am ready for the matter. And my lords is well aware of income tax.
How do you know that?
I know, my lord, I know.
Assessment order was for, that is appealable order. Now. there-
Assessment order has been passed. Then why are you
My lords, but my point here was that the 148 AD order has been passed 3 times, my lords. First 2 times, the AO held that it is a not fit case. On the 3rd time, after getting instruction from his superior, he made it a fit case.
But now it has become appealable.
Yes, my lords.
So why do you want to file it?
Then, my lords, if my lords is inclined, then I'll take instruction from my client and then say.
All the things kept open, the appeal, then second appeal.
Very
Not to do.
Not good. Lordship.
grateful.
Forty-seven.
47, my lord, I beg to appear for the petitioner. My lord,
Or the respondent, National Highways Authority of India.
my lord, the petition, this writ petition was initially preferred. My lord, being aggrieved by the fact that, my lord, in lieu of acquisition of, my lord, a piece and portion of the tea garden, the amount of compensation determined by the state authorities with regard to damage to the shade tree and bushes, despite being determined in 2016, that was not paid. Claiming that amount of compensation, this writ petition was preferred. Now, my lord, when this writ petition was heard, if my lord kindly takes the last order passed by Honorable Justice Vishwajit Basu, my lord would find that on the date of hearing when this was last considered, the National Highway authorities said that they are ready to deposit the amount with the competent authority. Now, my lord, so at the same breath, it was further submitted that the National Highway authorities is contemplating a challenge against the determination. Determination, it can be challenged before the statutory arbitrator, that is the divisional commissioner, thereafter, my lord, section 34. Now, my lord, subsequently, all this, my lord, what they proposed to challenge, the challenge was carried out. Section 34 was, my lord, the arbitral proceeding before the statutory arbitrator, it went against them. Section 34 was preferred before the landed district judge. That challenge was also failed. Now, my lord, if my lord kindly takes the last paragraph of the last order passed by Justice Basu, this writ petition was kept pending, my lord, pending their challenge. The writ petition on my prayer was kept pending so that I can make appropriate prayers for disbursement of the amount. Now, my lord, since all remedies has been exhausted by them and that went against them, that I am only praying, my lord, now this amount be, my lord, disbursed in my favor.
No, Lordship.
My lord, the last paragraph, my lord, would kindly take that.
Just a minute. Give me a moment. I'll just.
Yes, I understand.
Yes.
So Lord, Lord, before she takes over, Millard, the last paragraph. Millard has seen internal page 3, Millard, the last paragraph. The court said for the closing sentence, for appropriate relief in the event the compensation is not disbursed in terms of 3H.
Yes, Lordship. Subsequent to this order, they have filed a contempt application. In contempt, we stated that the entire compensation, disputed amount and undisputed amount, both we deposited before the Kala. We are no objection with the undisputed amount, but the regarding disputed means 4.18 crores, Lordship. We have filed in section 3G5 application where the learned arbitrator dismiss our application on the ground of limitation. Subsequently, we filed an application before district judge under section 34, Lordship. In that application, our London district judge, our limitation point was in our favor that the application is under limitation, but the other portion was against us. The order of London district judge was passed on 28th May 2025. Very recent order. We have by letter dated by letter number 996, the National Highways Authority for further challenge under section 37 of Arbitration and Conciliation Act recommended to the LA Committee of the National Highways. That recommendation yet to receive, Lordship. That's why we have not challenged, but we will challenge by next week. And we are under 90 days because the Arbitration Act itself allow us to file any appeal within 90 days. We have still 30 days left, Lordship.
Millard, Millard, since 2016, this amount, Millard, have been deprived from the legitimate amount which has been quantified by the state authorities. Now, Millard, whatever they wanted
by the petitioner before
Millard, whatever they wanted to do, that should have been done. Now, that having not been done, Millard, what stops from making the disbursement?
Yes, Lordship, this
Subject
is the public
challenge,
money
Millard,
without availing all the legal proceedings.
Millard, subject to approval of your Lordship can record without prejudice to their rights and contentions. In the event the challenge is successful, I will be bound to return the money.
No, Lordship.
No difficulty, but the money has been disbursed. Despite, Millard, an admission on their part that they want to pay the money, Millard, we have to go to a contempt.
Was that they
We want to deposit.
Now, despite that, not a single penny was deposited until and unless we prefer the contempt application.
No, Lordship, wrong submission. We have deposited the undisputed amount.
The order in contempt?
Before the order of the contempt, we have submitted the entire compensation,
Millard,
which
there
was
no
disputed.
order passed in the contempt. Millard, once the contempt was taken up, before it was taken up, they deposited it. Once they were served with the notice. Millard, they have deposited the entire amount. That was quantified.
DG and all.
Yes, Millard.
National Highway Act.
Lordship, may I hand over?
Millard, we have two sets. Millard can have a call.
On 8 February 2024, Lordship, 1.90, we have deposit. That is undisputed amount. And rest amount.
Dispute undisputed has to be before a court of law.
Yes.
They have not disputed this amount since 2016. When we preferred this writ petition in 2024, they chose to challenge the determination.
We prefer several letters.
The dispute cannot be Millard, argued from the bar.
We wrote several letters, Lordship, before the competent authority to revise their estimate, Lordship. Ignoring that, the competent authority tied over this matter, Lordship. And subsequently, they have placed an 6.54 crores rupees
So they admit in the proceedings, they have not paid compensation under the original Requisition Acquisition Act. You also know that, my lord, in the original Requisition Act, there's section 7A was inserted, and within 3 years they have to pay. Yeah. What is it?
Yes.
So, my lord, I was supposed to direct them to file a report to whether they have, and this is after judgment, just Arun Mishra's judgment. Paid means the deposit or not, but they have themselves said compensation was not paid.
It was reserved since there was no, we were, if, your lordship, I can supply a copy of the report.
Sir,
Not for it.
Then I said, I will see and then come on.
very well.
Mon-
You want to respond to it?
I don't know what is there.
What
So,
should I do?
Monday, you should give it.
Monday. A report filed on behalf of the state in terms of the order dated November 6, 2024 is taken on record, full stop. A copy thereof has been served upon the learned senior advocate appearing for the petitioners, full stop. Mr. Rai, learned senior advocate appearing for the petitioners, seeks
Lordships. And item number 51, I am for the respondent number 126, your lordships. We have already filed our report.
Your I. Of this honorable court. The central has already given a report. It was state government to file a report before your lordship. This is related to the 52 Act, where my property was acquired by the parties for defense purpose. And they had to matter to arbitration. Nothing at all was done by the state authorities, the central authorities. Now, after I filed the writ petition,
Mr. Chatterjee,
central
Mr. Chatterjee, you are partly audible and absolutely invisible.
My lord, I am for the petition. I am led by Mr. Chatterjee, my lord. If my lord kindly give
Only invisible and was a little bit audible. Now he's invisible and inaudible.
there was some problem at my lord's end. So I had multiple devices being activated. So as to
Now you are visible but not audible.
Bro, I'm really sorry, my lord. This is the problem at times if you don't get internet connection. And I'm inside my lord's court in courtroom number 15. So, my lord, now the problem is, if your lordship has heard anything that I have said, my lord, so far, no.
I heard a lot of things but couldn't make out anything of what you said.
I'll tell you, lordship. The writ petition is with respect to the 1952 Act. This act is applicable where, my lord, my property is acquired by the central government for defense purposes. This is, my lord, a tea garden. So during the China war, my lord, they wanted this property, my lord, to use it for their defense purposes. Now, after 1952, my lord, after my lord, the acquisition, there had to be, my lord, the proceedings under, my lord, the 1952 Act, where an arbitrator had to be appointed and a money had to be paid if I did not, my lord, agree with the amount that has been paid to me. They did nothing. So I filed, my lord, a writ petition. After the writ petition is filed, my lord, the central government filed a report saying that they paid the money, my lord, to the state. And now the state government is to disburse. That I am to get the money. Right now, my lord, there is no dispute. The Honorable, your Lordship's court, my lord, as far back as in 24, my lord, wanted the state government, my lord, to file a report before your lordship as to what did they do with the money. The last extension, my lord, was given by Justice Joy Shen Gupta, my lord.
Yes, on March 12, 2025.
Yes, and it was a mandatory.
I am for the respondent number 126, your lordship.
The state government was represented, my lord, by the.
Mr. Saha.
My lord, item number 51, the affirmation is going on since I did.
He says affirmation is going on. It is being
My lord,
affirmed.
this has been going on for the last 1.5 years.
No, today my junior has gone.
I'm passing it over. He'll probably file it today. So
Then, my lord, no, then let them serve us a copy, my lord, then we'll.
yes, yes, so I'm passing it over for the purpose of receiving it.
Very
I'll
good.
receive it. I'll pass an order to serve it on you, and then we can meet next week or whenever.
I'll appear before your lordship. I'll appear. So grateful, my lord.
Passed over.
My lord.
Passed.
My lord, before calls your lordship, the previous next matter, item number 43, my lord, I was appearing, but due to the technical glitches, I could not enter.
You will have to wait, Mr. Lahiri, for your turn now, because
Yes,
we
item
long
43.
past 43.
I understand, my lord, due to the technical error, I could not enter.
Very
my lord,
well.
there's
I
an
haven't done
urgency in
anything.
this matter. Well, there is some urgency in this matter. Your lordship kindly
Very well,
takes
let
it
me
up.
come back to it because
Yes,
I
yes.
have.
Yes, I'll wait. I'll wait for your lordship's call. I'll wait for your lordship's call.
All good. Good.
Your lordship, I am for the petitioner, your lordship.
Not this week. I'm making not this week. On Monday, you file it.
Lordship, there was
Not
one
this
more direction regarding the affidavit in opposition. Was it that? Affidavit in opposition, but in the order it is an affidavit in opposition. In the report, in
Very
the
well.
order.
I'm making it not this week.
Your
Whatever
lordship,
it is,
your
they'll
lordship.
file on Monday.
One thing is there, your lordship, previously also, the time was extended for them for filing that affidavit in opposition.
If they file it on Monday, your matter will be done.
Stabilized, your lordship.
Not today. Ah, sorry, not this week. Not this week. I said not this week.
Lordship, I'm appealing for the petitioner. Lordship, the direction was given to the state to file a report in the form of affidavit. It is not submitted yet, Lordship. In the month of November 2024, the state was directed to file.
You were directed to serve a notice on the state because they did not appear. Have you served?
Lordship, we have served.
No. By order dated June 30, 2025, you have directed to serve again.
Is not served.
Serve a fresh notice.
Lordship.
Serve a fresh notice. I'm not passing any order. It will appear on Monday.
Lordship.
In terms of this order, you serve notice telling them that it will appear on Monday. Or should I pass a fresh order?
Lordship, make it not today. I will serve in this during the course of the day.
Not this week. I'm
good.
In 54, my lord, I am for the respondent number 4, my lord, Distribution Company Limited. Now, my lord, this matter, my lord, today I am filing opposition, my lord. Reply has already been filed. Now, my lord, what I am on, my lord, subject to
Petitioner
what.
is. Let the petitioner come. You are for the petitioner?
Yes, your lordship, I'm praying for a short Passover, your lordship.
No, he's filing his opposition today.
Yes.
Have you been served with the opposition?
Should I take?
No, my lord, he has been served, my lord. However, my lord, then my lord, reply is, in fact, my lord, reply has also been forwarded to me, my lord. I do not know whether it is being
very
filed
well,
today or
then.
not.
Then I'm passing it over then.
Then, my lord, lordship, kindly make it not today.
Not today, kindly make it not today, your
Then,
lordship.
lordship, kindly record an order, my lord, since we are filing it today, my lord. Kindly record
By
an order.
recording an order, I will not keep it tomorrow. You come tomorrow ready. If you have served, we'll hear it.
Lordship.
My lord.
Not
then, my lord, lordship, subject to lordship's kind consideration, my lordship can do one thing, my lord. Since, my lord, I have filed the opposition, my lord. Kindly record
They
it,
have
my lord.
also forwarded a reply unnecessarily. I'll take the opposition, pass an order. Then tomorrow I'll take reply, pass
No,
an
then,
order.
my lord, kindly stand it over for the next week,
Let
my
us
lord.
see tomorrow. Both the parties may be here. We can finish the matter. Why are we arguing on this?
My lord, my lord, my lord.
My lord, for item 52, I am for appearing for the petitioner, my lord. My lord, in the last occasion, there was a direction to the respondent number 2, being the Sabhavati of Jala Parishad, to file a report. Till now, they have not filed any report without giving any notice. And in the last order, that is 18/6/2025, the coordinated bench has given a last chance to them to file a report. But till now, they have not filed any report regarding the demarcation of the particular land.
Yes, you were given last opportunity by the last order.
Yes, your lordship.
Lordship, we have served notice, but the verification is not yet complete. Because there is that of technical person, because the land is too measured.
So you file it by
There is
Monday.
that-
I'm making it not today. You file it not this week. You file it by Monday.
Lordship, today's Saturday.
Tomorrow is Friday. Saturday.
My lord, since long they are taking time, they are not filing any
Because
report.
otherwise I'll have to hear it. Last chance was given.
Yes, your lordship.
I understand, they were served
So
notice.
it is up to you. sir.
Already my land
I
has
don't
been
know. It
encroached.
is up to
And
you.
the road
If-
has been constructed.
If on Monday you are ready, then it is all right.
Because already there is a report submitted, there is allegation of encroachment of the land of the Jala Parishad.
Yes, there was
By
a.
the petitioner.
Sir, in terms of this order dated
Lordship,
18th
then
of
we
June,
pray Wednesday, we will instruct accordingly.
I'll keep it on Monday only, not this week. If I pass any order, then this last opportunity will be recorded and
Yes, my lord.
I will close.
Simply they are
Are we
taking time.
expecting-
It has been recorded last opportunity.
I understand.
Then
Because they have been served after that.
There is
Report
no
is done,
notice,
sir.
there was no
you-
notice that was served to us.
Was done.
Regarding the inquiry, there was no notice to be
No,
served,
it
as per the
was-
instruction that I have received, my lord.
Yes, no. I will try to.
I don't know, try or not. On Monday, if you are not ready with the report, I will proceed because
Lordship, we
last opportunity was given. You have to do it. You should have said so. They don't record last opportunity. If last opportunity is recorded, I cannot supersede that order. Not this week, kore
I
rakho.
will-
You tell them they cannot take orders so easily and so lightly. If it has been
Because it
said
is
that-
our land of the Jala Parishad.
whatever land it is.
Without filing any
Because
report, how can
not-
they say that
an order of court-
that is
There
the
is
their
an
land,
order
my
of
lord.
court saying last opportunity means last opportunity. It doesn't mean
That I
second last,
understand.
third last.
Monday will pray that because there is no technical.
I will not grant any time on
No,
Monday.
no, no.
I'm very
We will
clear on
speak
that.
Directly more upon the concerned BLO because they are the record.
I will not give any direction also. Your opposition will not be there. I will proceed on the basis of whatever is there on the record. I'm making it very clear. You kindly tell this to the authority that the matter, and this I will record that the last opportunity was given. Please
Yes,
don't take it so lightly. Last opportunity has been recorded in the order. Still you are not filing. This is not proper.
Because problem
And
is that.
since
the land
January,
is
the direction was given to
Jala Parishad does not have the technical.
So why did you not oppose on that day when last opportunity was being recorded?
That
Then
we could not follow that order.
that is the problem.
Jala Parishad-
Since January, they have a direction to file the report, but they are not filing.
Whenever court passes an order, if there is a recording that it is last opportunity, it means last opportunity. That's it. I'm not the appellate court. I'm also a single bench. I cannot supersede that order. I'll have to follow it. You may not follow it.
Whatever the report, I will ask them to file on Monday.
Whatever it is.
Yes.
Grateful, man.
I'm for the petition. But the issue here, my lord, they may pay for, I just say that they ask for. What happened, my lord, the petitioner, people ask you the guardians of the students in the school. They have challenged the order of the transfer of the headmistress in the school, which is in violation of the, completely violation of the transfer policy. But I should say, my lord, people lordship, earlier the assistant headmaster of the school, who also challenged this order of transfer of the headmistress. And that was heard both sides. On the question of locus standi, that was dismissed. And then I also prefer the appeal. Appeal also held same thing. So my kind of last order is there. My lord Justice Sheena was pleased to pass the order that yes, now the
Division
appeal
bench judgment was supposed to be placed.
given them, they are also. my lord.
Your
So
lordship,
now on the question of locus standi, that was dismissed not on merits. So my, this is my lord judgment.
your lordship, one indulgence before my learned senior starts, your lordship, I'm led by Mr. Shoptangshu Basu, learned senior counsel, your lordship, kindly fix this matter any day apart from Monday next week, your lordship, he would be appearing in this matter on
Mr. Basu,
behalf of behalf of respondent.
I can't stay in the corridor.
You give the judgment, I will also consider. Learned Mr. Rai, learned senior advocate appearing for the petitioner.
Mr. Bashu is there, but I cannot go there. Next is ours. নেক্সট কি আছে উত্তর দেওয়া নেই
ফাইলগুলো পাঠাবো করে নেবেন
তুই কি একটু
পড়ে আসবে তাই তাড়াতাড়ি
উত্তর দিতে হবে তো
সব পাঠিয়ে দেবো
উত্তর আচ্ছা থ্যাংক ইউ নেক্সট ইজ মাইন্ড মাই দিস my land has been acquired. This is some dish for a good. What is it?
my report mala.
Copy them, okay.
Hey, Devin.
Our copies.
Yeah.
Then I'd give the exception.
A report in the form of affidavit filed by the respondent numbers 2, 3, and 4. Of a copy thereof upon the respondents.
Yes, also.
Exception.
I'm saying this
may be filed in the meantime with a prior service. of
I'm
a
saying
copy
this one.
thereof upon the respondents.
No, this all, I'm saying this one. Many is there.
So on the state.
Yes.
On the respondent numbers 2 and 3.
Yes.
2 and 3.
I am appearing for the respondent number 7 and 8.
Very well. Naam
I am appearing for the respondent number 7 and 8.
Very well.
GTA.
Is it?
Fifty-eight for the state model.
But 58, my lord, I am the petitioner. My lord, the matter pertains to, my lord, non-disbursement of compensation amount, my lord, land acquired by the National Highway Authority. My lord, there
was direction to serve upon the private respondent.
private respondent has been served, my lord.
Lordship, but we don't have any copy of the petition, Lordship. So Lordship, kindly keep this matter on Tuesday or Monday.
My lord, Monday, my lord, I will serve them. In the course of the day, I will serve them, my lord. Fix it on Monday.
Monday, not this week. Making it not this week.
Lordship.
No. Not this week.
Item number 59.
Lordship, I am appearing for the petitioner in item number 59.
15.
My lord,
The petitioners,
Yes.
the petitioners are the grandson of the respondent number 5, and the respondent number 5 gifted some properties to the petitioner, and subsequently the respondent number 5 challenged as gift deed before the subdivisional officer under invoking the provision under Maintenance and Welfare of Parents and Senior Citizen Act
What is this
2007.
CAN for? CAN? What is this application for?
Plus, application was filed subsequently after filing of this writ petition. We came to know that
Lord,
the
no
deeds,
copy has been served upon us.
We don't have a copy of the.
Just
the deeds which was cancelled by the subdivisional officer in the proceedings under the Senior Citizen Act was actually the order of the subdivisional officer has been carried out by the register, has been executed by the register, and the deed has been cancelled.
What do you want to do by way of this? Can you want to bring something on record, or you
No,
have?
Lordship, no, Lordship. That this fact that these deeds have been cancelled by the register also.
They say they have not received a copy of this application.
Yes.
Respondents, you have not served a copy.
Lordship, probably it was missed. Then I will serve it today, Lordship. I will serve it.
Serve copies on them.
Lordship, kindly,
When-
Lordship, then Lordship, kindly fix the matter on Monday. I will serve in the meantime. And
My Lord, if I may come in here for a bit, my Lord, there was a direction upon us to file the affidavit in opposition, my Lord. We have not been able to prepare it, my Lord. I need some time, my Lord. I'm for the private.
direction was given long ago, Lordship.
January was January.
Yes, my Lord. There was a direction.
How soon can you file them?
My Lord, a week. A week. A week.
Within a week you'll file?
Yes, yes, yes.
He seeks a week's time to file the affidavit.
Okay, Lordship.
You are appearing for?
For the private opposite party. The respondent numbers 4 and 5.
5 and 6.
It's a tussle between parents and children.
Yes, my Lord.
Grandparent and grandson.
Grandparent and grandson. Why are you fighting with your grandparents?
My Lord, my mother is living with me. My mother happened to, my Lord, execute certain deeds in favor of her grandsons. And she was influenced by her other sons and, my Lord, the daughters-in-law. So, my Lord, subsequent to that, when all of this came to light, she happened to file an application before the SDO. And, my Lord, the SDO, through a reasoned order, after coming to a satisfaction that yes, indeed she was influenced by them, and whatever was promised to her was not given to her subsequently, which is taking care of her. And, my Lord, her ATM card was also, my Lord, taken away from her. And, my Lord, money was withdrawn from her account. All of these facts were, my Lord, considered by the SDO, and the SDO ultimately came to a
Under
conclusion.
what proceeding?
My Lord, under the Maintenance of the Senior Citizens Act, the power.
So that order was challenged.
Yes, and that order itself has been challenged in this proceeding.
Is there no provision for appeal?
No.
No, Lordship.
There is a provision, my Lord, but they have.
Only the senior citizen can.
Yes, before the district magistrate does it. Yes.
Appeal is
So
for only
if
for
there is
senior
a
citizen.
provision for appeal, why have you approached the writ court?
Now, Lordship, there is no provision for appeal for me, Lordship. I am the petitioner in the writ petition.
Yes.
And I am the grandson. I have no provision for appeal.
If the aggrieved is the senior citizen herself, then the appeal lies.
23.
Very well. Then the affidavits are required. File it within a week.
Yes, my Lord. Yes, sorry.
Learned advocate appearing.
My lord, with respect to item number 61, my lord, 60, rather 60, my lord. Yes, my lord. This will take, my lord, I have to be before your lordship. My lord, if your lordship fixes it on Monday, my lord, will it be very inconvenient for my lord?
No, no, it's okay. Monday I can, every day is same for me now, Mr. Chatterjee.
Yes, I get that. My lord.
Not this week.
Not this week.
Yes, he wants it on Monday. So if it is not
It is
this
not
week, it
this
will
week.
be-
Yes, yes.
I'll be there before your lordship on Monday. My lord, this will not happen online.
Not this week.
ওটা
Not
বলবো?
this week. I'm making it not this week simply, so
39 টা
My lord, if it commences to your lordship, can it be upgraded a little, my lord, so that I can take
it will be,
the evening's flight?
it will be upgraded only because
Very well.
other
So
matters.
grateful.
No inclusion. This is the reason it automatically.
So
From Monday, Lordship, the mentioning will be taken up, then it can be included.
Yes.
So
So
you're.
39 টা বলবো?
হ্যাঁ বল।
It will
So
be
great.
automatically upgraded.
Millard,
My lord, is the in that other matter, passed over matter, my lord, with your lordship?
Yes,
would be
yes.
taken?
Astover একটা ছিল না ওই যেটা অ্যাফিডেভিট ফাইল করবে বলেছিলেন সেটি কল করুন তো
First over, this is 39.
Millard, since the learned additional advocate general is here, Millard, item 39 was also passed over. Millard, can I make a prayer, Millard, if this can be, Millard, taken up on Monday? Millard,
39?
Yes.
Not this week. Monday.
And Millard, Monday,
So what, matter can be taken up now?
it's 3:30 আছে না আজকে?
3:30.
I have no issues. 3:30 is for you.
I have no also, the state has no
No, my
option.
lord, your lordship is
Then
also
very
a member of the
State has
bar.
no option.
It's also for my lord.
So it's up to you.
It is up to you. I have to
Since
even.
there is a resolution, Millard, it would not be proper probably, Millard.
Very well then.
Millard, can it be taken up within the first 10 matters on Monday? Because
That I cannot promise. First 10 I cannot promise, but
And don't
it
give
will
me
be
a
taken.
burden. But you know, all these
plus
matters.
very, Millard, a larger issue is involved. Millard, it's a decision of a state, Millard, to assign jurisdiction in a court of Siliguri. That is under
Very
challenge.
good. Then I'm making it not this week.
Not this, sir,
Monday will be okay.
Oh, no problem.
Monday করে দিন।
some
Not this week.
precedence if possible.
আর
Millard.
একটা ওই অ্যাফিডেভিটের ব্যাপার ছিল কি
Item 43 as well.
Yes, of Monday, it can be a Wednesday.
Please wait, Mr. Lahiri, please wait. There is a matter where
No, no,
affidavit
no,
was
but
just to be filed.
আর পিছনে ঠেলো না, let it be on Monday.
Monday আমার অনেকগুলো ঝামেলা আছে।
থাকুক না, কি আছে? এইখানেই তো আছে।
Can it be on Wednesday?
Millard,
It can be on
No,
Wednesday.
Millard, I have, Millard, an interim order to press, Millard. It was taken up by Justice Ghosh yesterday.
What is the how?
Wednesday you seek for interim order.
It's a good day for you, Mr. Ghosh.
Millard, Wednesday, then Millard, if
what?
Millard kindly gives it some precedence
Yes,
on
that's
for that.
Precedence, I cannot promise because I don't know what more urgent matter will come before you.
If Millard fixes up a time, probably 12 o'clock, 2 o'clock, whatever.
No
Millard.
fixing of time. If you want it on Wednesday, it will be on Wednesday.
Yes.
But I think we should reach.
Yes.
I won't be that slow as I am today.
No, Millard, that's not the question, Millard. So that item number 39, Millard is taking on Wednesday.
Wednesday ওটা Wednesday date দিয়ে লিস্টে রাখুন Wednesday date দিয়ে দিন। তাহলে আর কোনো order
One
pass
matter Monday, other is Wednesday. Grateful.
Not this week means Monday, so
Yes.
no date is fixed there. Here I'm fixing it because he wants a date. Otherwise, I'll have to pass an order. Should I pass an order then to that effect?
Not required. Wednesday.
Not required, Millard. Let it be taken up.
Ramdev is on Monday. Jira first
Item কত
item
ছিল জানেন?
60 is Monday.
Monday.
39 is Wednesday.
Wednesday টা date দিয়ে লিস্টেই রেখে দেবেন, ডেট দিয়ে দেবেন, তাহলে সুবিধা হবে।
Then Malad, kindly.
Monday I made not this week, so it will automatically appear on Monday. Not this week means because there are several matters as not this week, so I'll have to fix all these. Yes.
না আমি দেবো তো এটা ডিল
Thank
করবো।
you.
Malad, I think this is your first visit in Jalpaiguri, not as a judge, even.
No, even as an
As
advocate.
that.
I have never been out of Calcutta.
In 51, there was a direction to file report in the form of affidavit, my lord.
Yes.
We are filing the report. Also, the state respondents are seeking liberty to file an affidavit in opposition in this matter. And a report we are filing today. If affidavit on opposition direction can be passed.
Lord, kindly hears me once on this, and thereafter, my lord, your lordship passes any affidavits, because this is also, my lord, a part of delaying, my lord, the entire issue.
No. My lord, it's a land acquisition matter without affidavit in opposition, whether it can be heard or not.
But there was a direction for opposition also.
They have not filed
March 12,
for 1.5
2025.
years.
My lord, last order, there was a direction to file report in the form.
As last opportunity for the state, let the opposition be filed positively within 2 weeks from this date. That is what is written.
My lord, there was.
This is pretty.
But there might be a typographical error, my lord. I believe so, because there was a.
My lord, it's not. There was
Reply
a
be filed within a week thereafter.
Yes, exactly.
It says opposition and then reply.
Then, my lord, grant us extension of the time to file an affidavit.
Last
Kindly, my lord,
I filed the report today, my lord.
Then
Let
we'll
it be
hear it.
preempted, my lord. Let it be preempted, and my lord.
Let us hear. Report currently. Report filed on behalf of Mr. Chatterjee, you want to take an exception to this report?
My lord, I haven't even looked at it. If required, kindly, my lord, gives that direction, if required.
So when do I fix it then? Because if you find
My lord fixes it on Friday. I'll be there before your lordship. On Monday, I'll be there, and Friday also, my lord, I'll be there before your lordship.
So, my lord, Friday,
That's it.
I have personally given.
he will not be there on Friday.
Thursday,
Oh, next week. Yes, next week. Next week, Thursday and Friday.
that's exactly what I'm saying. Next Friday. I'm not saying this Friday. Next Friday.
Friday week.
Friday.
Very well. List this matter for further consideration on July 11,
Yes.
2025. The petitioner shall be at liberty to file exception to this report in the meantime. Mr. Chatterjee, your client will be at liberty to file exception to this report in the meantime.
Lordship, if required,
Okay,
I'll
for your lordship.
by way of exception.
You
Kindly
file.
pass that.
Parties,
Lordship.
petitioner take parties করে দিন.
Yes.
Parties shall be at liberty to take exception to the report in the meantime.
Lordships.
So great.
লাহিরির একটা কি ম্যাটার ছিল?
Yes, my lord.
Yes, Mr. Lahiri, what was it?
That was item 43, my lord. I don't know whether the other side is appearing.
Yes, other side.
Yes.
You're
My lord,
43.
may I just place it before your lordship?
43.
No, এটা না, দিকটা দাও। জোসেফকে দিয়ে দিও।
উঠে যাবে
দিকটা নাই।
My lord, your lordship has got the file of, may I place it?
Not yet. Please wait.
Wait, my lord.
এই ফাইলটা নিবে, আমার ফাইলটা নিবে। Yes. Mr. Lahiri.
Yes, Mr. Lahiri.
Yes, my lord. My lord, the petitioner before your lordship was a primary teacher. He was rendering his service as a primary school teacher. Now, in the first state level selection test for upper primary level of selection, he became successful and he has been awarded with the recommendation letter for joining. Now, my lord, he is about to join to the new school, that is the upper primary level. That is primary is 1 to 4 and upper primary is 5 to 8 to the fresh recruitment process. Now, the issue is, now since the petitioner has been rendering continuous service in the primary level, so he has acquired a length of service for which his salary is higher than the new joining, that is of the upper primary level. So, my lord, there is a pay disparity. So, in primary level, though the pay band is higher at the upper primary level, but at the primary level for rendering a long prolonged service with the improvement, now he is going to get less salary than the primary level, which he has been enjoying so far. Now, my lord, for that, what happened? A prayer has been made for consideration of the pay parity, since there is a notification, government notification, that when someone is coming from lower strata to higher strata, his pay will be protected accordingly. So for which he has made an application for consideration. Now, there is a provision for consideration that it would be considered by the state authorities, that is pending presently. However, there is no problem to that effect. That prayer is already there, so that it can be considered. Now, the problem is the similar issue came up in case of other applicants also, those who had faced the similar difficulties. Now, in the meantime, their date of joining is approaching. 7th July is the last date within which the 90 days, the validity period of 90 days between which he needs to join to the school, since the appointment letter has also been issued. Now, considering this issue, the coordinate bench of this Jalpaiguri circuit bench, the bench allowed lien for the primary school teachers that yes, your claim for pay protection at the upper primary level will be considered. Till then, you will be given lien for 1 year, extendable up to 1 year. So the similar relief I am praying before your lordship, I have two prayers. Firstly, my representation for pay protection is to be considered in accordance with the notification. And till it is being considered, I may be given lien at the primary level, so that in case I don't succeed in getting the benefit of upper primary level, I can come back to the primary level. My lord, first, I would show to your lordship that I was appointed as a primary teacher. My lord, am I clear to your lordship? Am I audible to your lordship? Yes.
Yes,
I'm extremely grateful to your lordship. My lord, first takes up page 22. That is my first appointment as primary teacher.
Yes.
That is on 2nd of February 2017. I got appointed under Jalpaiguri District Primary Council in a primary teacher. So I got confirmed also. Now, my lord, kindly come to page 25.
Yes,
ma'am. I'm so grateful. Page 25 is the fresh recruitment recommendation issued by the School Service Commission in upper primary level. You will find the date at the right hand side corner, 8th of April 2025.
Yes.
Now, the next page, that is on 28th of April, I got the appointment letter from the school also. At upper primary section. That is dated 28th of April 2025.
Yes.
Now, my lord, just to remind your lordship that the validity of recommendation letter is of 90 days. So 7th of July, it is going to get over. In between, I have to join. Now, my lord, kindly see page 33. I have made a representation on 15th of May 2025, just after receiving the recommendation before the chairman, District Primary School Council, Jalpaiguri, who is to grant me the lien, as well as before the other authorities. So far, the lien is concerned, I'll kindly see my prayer. Prayer for protection of pay at upper primary level by counting past service rendered as primary assistant teacher, and thereby fixation of scale of pay, allowing all admissible service benefits by counting past service at primary level and non-requirement of no objection certificate from the previous employer, and issuance of lien for 2 years at the primary level for joining to the upper primary level. So, my lord, this was my prayer, which is pending consideration. Now, my lord, similar issue came up before this bench. Before that, my lord, I would draw your lordship's attention to page 46A, P4, page 46A. That is my entitlement, which allows my pay protection at the upper primary level. P4, page 46A.
Yes.
Notification dated 16th of April 1996. Your lordship has got it?
Yes.
I'm thankful to your lordship. But kindly take 2B. 2B.
Yes.
When the latter post carries duties and responsibilities of greater importance than those attached to the former post hold by the increment, the pay shall be fixed in the timescale of the pay post in the manner as laid down in notification in para 7 of notification such and such of 26th of October 1981 issued by the department. So, my lord, there is a provision for consideration of my pay protection when I go to the above level, from primary to upper primary level. Now, my lord, considering these similar matters came up, kindly come to the next page, page 47. That is the order. And already lien has been granted during pendency of my application for pay protection. Lien has been granted. Page 47 is the coordinate bench order. There only one difference. They applied before the authority rejected. When that was again challenged, in the meantime, this order was passed. Now, the relevant portion is at page 50.
Please wait, Mr. Lahiri, let me go through the order.
Yes, yes, my lord, my lord.
Yes.
Yes, my lord. Now, my lord, what would be the consequence if I don't get lien today? Now, I have to tender resignation at the primary level. Then only I'll get the release order. I can join at upper primary level. Now, if I tender resignation at primary level, I cannot come back the primary level and I'll be forever stuck in upper primary level in case my pay protection is not granted. So that was considered by the coordinate bench and allowed lien. In the meantime, my prayer for fixation at higher rate is being considered. So, my lord, the similar relief I am praying before your lordship that lien may be given by the concerned DPSC for 1 year initially and extendable up to another 1 year, and release may be given accordingly so that without claiming for the resignation, I may be released on lien so that I can join at upper primary level. If I am not, humble prayer.
Yes, sir. Lordship, we are from the bar. Members of. No, we have come from the bar. So reciprocally, we are following the resolution of our principal bench.
Acha. Mr. Lahiri, we'll continue tomorrow.
Very well, very well, very well. Very
Helpful, Lordship.
Let it appear tomorrow at the fairly at the top. I expect, my lord, it will appear at the top.
Affidavit of service টা ফেরত দিয়ে দিন এখন কালকে আবার নেব ফেরত দিয়ে দিন
My lord, I thought they appeared to argue. I'm sorry if they did not want to. I thought they appeared to argue.
Thank you.